My lords,
May
if I
it
could
please
just
my
make
lords,
one
I'm sorry.
mention.
For my lords' convenience, I have prepared a list
My
of
lords,
may
if
it
I could
please
just
my
make
lords
one
in the matter
mention
for my
on behalf
lords'
of the
convenience, along with the indicated time per council. It's as per the seniority. Mr. Sibbal.
My lords,
But
just
I've
wanted to
just
make
prepared
one.
this. No, I'm just 1 minute. I've prepared this for your lordship's convenience as per the seniority.
My lords,
May
if I
it
could
please
just
my
make
lords,
one
I'm sorry,
mention.
for my lords' convenience,
List is
as per the seniority. A list of
My lords,
may
if
it
I
please
could
my
just
lords,
make one
mention at the
mention
bottom.
on
My
behalf
lords'
of the
convenience,
petitioners.
the interveners, along with the indicated time per council. It's as per the seniority.
My lords, just wanted to make one mention. My lords,
Today, 1 second.
Mr. Sibbal.
My lords,
But
just
I've
wanted to
just
make
prepared this.
one.
No, I'm just 1 minute. I've this for your lordship's convenience as per the seniority.
My lords,
as per
may
the
it please my
seniority.
lords, one
I'm sorry,
mention.
For my lord's convenience.
Today I wanted to make a
Just 1
mention.
second. 1 second. We will, after Dr. Singhvi is done, we will hear Mr. Vishwanathan. But on this side, we have to complete the arguments today. We complete the wrap up the arguments of this side today. No question of going beyond today. We have now heard two learned senior counsel who have taken us through everything. Maybe a third learned counsel on this side would also be arguing. Everybody else may now,
My lords, I just asked for 20 minutes.
at lunch, no, at lunch,
End of the day,
all,
10 minutes.
at lunch, 1 second, at lunch, all of you please sit down and ration the time in such a way that by 4 o'clock, this side is complete. So that, no further, and then we have to give the other side enough time. So
May I submit one aspect, my lord?
now 1 second. If I'm having a very long telephonic conversation, my better half only does this to me, which is please now get on with your work and stop the conversation. So I'll just say on the mentioning, no more mentioning. Dr. Singhvi, please argue.
I'm obliged.
Only one aspect, my lord, regarding an intervention petition, my lord. May I submit, my lord, with your lordship's indulgence, one aspect regarding the intervention application, my lord. I've moved an intervention application. I'm only seeking, my lord, less than...
Ma'am, there'll be 150 interveners. Please don't mention because we have to hear everyone else on the intervention now.
Because, my lord, certain theoretical aspects, my lord, of...
anomalies if we are not on other acts heard in just a little bit of fullness. My lords, if one extra day perhaps could be given.
No. Therefore,
The
absolutely.
heterogeneity, my lords.
There are Supreme Courts where the entire argument would have been over in 30 minutes. We have given now 3 days in this court. I think that's good enough. Yeah. We have.
No, we had indicated from the beginning that we are focusing on one issue, and therefore we are going to deal with it. Therefore, the requirement of other interventions, other periods, the nuances is not something we are looking into. So, just expanding the field again is contrary to what we had constricted to.
One of the issues which are not dealt with by my learned friends, one of the issues are not dealt.
1 second.
If there are 9 people and 9 people want to argue for 2 hours, what's the point of taking up a matter?
No, it is on. We are only seeking, my lord, a short time of...
Say, from 2 o'clock to 4 o'clock, you lordship may indicate the time. And everybody follows the time.
Yeah.
We don't mind. Please don't be like.
Just 1 second. Just 1 second. Just let's switch Dr. Singhvi, we will request Dr. Singhvi to conclude his arguments in 45 minutes by 12:15. And between Mr. Ramchandran and Mr. Vishwanathan, we'll give you an hour and 15 minutes.
First petition in the categories.
So therefore, we are giving between the two of you, Mr. Ramchandran and you, 1 hour, 15 minutes.
I have separate category. One and a half between my that's.
But I mean, why should one person get more time than the other? Because there's a diversity of views. That's why Lordship remembers.
You know, Mr. Grover, at the end of it, you have to otherwise.
No, I appreciate.
What we were thinking was next week,
Yes, my lords.
we will sit on Monday, Tuesday, Wednesday, and Thursday.
Yes.
Right? Next week we will sit on Monday, Tuesday, Wednesday, and Thursday. So we'll take it as we did in the case of Ayodhya. We had no miscellaneous. We were working through the week.
We are prepared to.
So we must give them also time.
We appreciate it. Milord, there are diversity of views on the same point. All I'm saying, don't ask us to argue for 1 hour, but everybody should get some time.
Of
Otherwise,
course.
and may I just
My lords,
honestly, just 1 minute.
But then you can merrily go on in July. We have no problem because all of us are traveling in the vacation.
Because Milord,
We'll take it in July. There's no difficulty. We issue as much.
We may be accommodated, my lords, just on Monday, we'd be very grateful.
I'll tell you why. Because after next week, this bench, Justice Call is traveling. My lord is not available after next week for a week. I mean, we have no problem. We'll keep it in July.
Your Lordship,
My lords, Monday, just Monday, my lords, pro rata, our time can be divided, the times that we have specified, the times that, subject to Mr. Ramachandran and Mr. Vishwanathan's agreement to this 1.5 hours, the rest of us will divide it pro rata and we will finish on Monday, my lords.
Absolutely, no problem, ma'am.
Because
Go on
the-
till August,
so the-
no problem. We'll go on till August.
yes, Milord, because the
No problem.
Lordships
Just
will,
Bhatt is retiring in October. We'll take up new bench after October.
no, your Lordships will
No problem.
appreciate, Milord,
Go on,
that
Merrily.
the councils who have started the arguments, Milord, of course, have an advantage because they've.
Problem. We have no problem. Let everybody go on merrily. There's no problem. We'll hear this. We'll also hear this.
You may not be saying this.
No, Milord, we are only seeking.
Either very clear, and I'm putting it very clearly. Chief has put it very politely. I'm putting it to you. People have to be bound by time.
Yes, my lords.
One.
My lords,
But
that
two,
is our commitment from
if
the bar.
on a particular side of different nuances and 10 people, it can't be that 10 people will argue ad nauseam. Then you point
Absolutely.
out only that nuance of it.
Yes.
And next
Absolutely, my lords.
We are giving everybody, but when you say everybody wants to look at the time schedule given, is this a realistic time schedule?
It was prepared in a different context, my lords. We'll cut it down pro rata.
People also know this case has been taken up with some priority. We are trying to wind it up. You don't want to wind it up, then don't wind it up.
My lords,
Go on.
my lords, we'll just take, yes, just 20 minutes.
Nobody is averse to, giving 20 minutes. But when you say somebody needs 1 hour 45 minutes, somebody needs 1 hour 30 minutes.
See, this estimate which you have given us is 16 hours.
Correct.
16 hours of hearing. Now, 16 hours of hearing effectively means, therefore, that if we
One
start
week.
at 11:15, that means that in a day we get 2 hours 45, 2 hours, about 3 hours 45 minutes. That is 4 complete days on one side. How can we do this? We've already.
Time is cut down, my lords.
Possible.
If the time is cut down, then
Stick it
this
20
time can be
minutes,
substantially
my lord.
decreased.
Stick to
We
20.
appreciate what's falling.
Just see, Vrinda, your time period, which has been given, and this is 1 hour 15 minutes. We are not denying you that. We will not deny you that. Not deny you that. Certainly, we will not deny you that. But everybody must wind up in that 15-20 minutes, which you
Yes.
get. That's all we are saying.
My lords.
When it's being rationed out, it should be equitable rationed out.
Of course, we'll do that.
Then why should one person get 3 hours and another 10 minutes? We have
Because
to decide.
people who have no.
But Mr. Grover, the person who opens, as you start in, Mr. Grover, we know in every matter. Why this matter? Even in a regular civil appeal or criminal appeal, if there are 10 accused, then after the first person has argued, the others basically
appreciate
don't supplement some different,
20 minutes.
some nuance, what is all.
My lords,
It can't be like this.
It can't
However,
be.
It can't be like this. After
My
the
lords.
first two finished, I think we've been taken through most of the things between Dr. Singhi and Mr. Mukul Roy. Now you are saying there are certain nuances which everybody wants to address. That nuances cannot be addressed as if you are beginning a new case and addressing.
No, my lord. No, my lord.
Of course.
Absolutely not, my lords. My lords,
We-
this
we'll
court
take
is
it,
way
we'll
ahead of
give-
the US Supreme
as
Court.
and
We
when
will adopt that, the US
As
Supreme
we
Court.
see the development, as we see how much time is being taken, we will ration times accordingly.
And we'd like other counsel at the upfront, when they, before they open, to tell us what they are going to argue.
Yes, ma'am.
Confine it down to the time which we will ration.
Absolutely. We'll do that. We'll all do that.
My lords, there is an intervention
You know, the other thing,
application.
I'm telling you another thing, and that Mr. Solicitor, Mr. Dwivedi, forget this issue and your arguments. If constitution benches really have to go on, you know, which 5 judges leaving their regular work, that's why Chief Justices before me have not constituted constitution benches, because you don't know the kind of pressure. Every evening I ask, what is the filing? How much is the disposal? We don't want to add to that's the real problem in our court.
Yes.
The inflow is so heavy. Unless we start rationing time, you know, it's impossible to list constitution benches.
Then your lordship may say that after Dr. Singh leaves, everybody is rationed out. We don't mind. that.
My lords,
15, whatever your lordship wants. In the interest.
See,
of time.
may I just say one?
Yes.
All this oral hearing which is happening is meant to give some voice to the people.
Correct.
But our real work begins after the hearing, right? So don't be under the impression that if you don't get to address to your heart's content, we will not apply our mind. Our duty lies elsewhere. That once this is over, the whole court system is right now geared as though everything depends on what you say or what you don't say, which is not correct. Therefore, please keep that in mind, restrain yourself to the extent possible, and present the clearest picture without taking us through too many things. If you start referring, then we will be shuffling pages. Our focus will be there. You want to argue, you look at us, make your point. Somebody said US Supreme Court, do that. Then don't refer to anything, just refer to the pages.
we will do that, my lords, and subject to my lord's preference, perhaps we could take that note, cut it down pro rata, and we will finish by Monday for sure.
All right, now what we'll do is, we have now indicated, we will start hearing Dr. Singhvi. Dr. Singhvi, wrap up by 12.
Lord, your lordships are, Lord, really
please.
keeping it on Monday.
It starts at 11:40, provided it starts.
Lord, your
Provided
Lordship,
12:30 that. Now,
He said
11.
yesterday,
I'll be racing.
yeah, we gave you a compliment of the expertise too.
Your lordship will see. I am not going to repeat a thing. I am only saying, please count my 45 minutes from when I start. That's all.
all right, Dr. Singhvi, we start now. Your time begins now.
Yes, only one clarity,
So
Lord.
turn to 142.
So what is your lordship's direction?
After this, yesterday we indicated we are going to hear Mr. Vishwanathan. Mr. Grover, you can argue after Mr. Vishwanathan. Mr. Raju Ramchandran after that for a bit. Then we'll hear. You have given us the order. That's great.
Yes.
No.
Your lordship,
Can I?
one.
All right. So after this, Mr. Ramchandran, then Mr. Vishwanathan, Geeta Luthra, Mr. Grover, Jaina Kothari, the order which you have given us in this.
There was an initial list, my lord, which was circulated by the nodal council, in which my name was included, and that seems to be, my lord, omitted from the revised list. I've communicated with the nodal council. I'm only seeking, my lord, a 10-minute
Who are you
time,
appearing for?
not more than that.
Why are you appearing?
In support of the petitioners, my lord.
My lord,
In support of the petitioners in the,
What is
the
it?
main guy.
Whom?
For a gay activist, my lord, from Bombay.
With 50 gay activists, are we supposed to listen to every gay
No, my lord, I'm only seeking a very short time, merely because, my
No,
lord,
but tell
the
us.
theoretical aspects, my lord, of anti-discrimination law,
We issue an
in particular, my lord, the theory of disgust by Mata Nuzma, only to elaborate on that, I'm only seeking 10.
Anybody who's an activist should come and address this court.
No, my lord, only
Now, proceed.
That
because, my lord,
can't work out like that.
Not like this.
How much time is your lordship saying?
Ma-
Anyway, Dr. Singhvi will complete at 12:30 and Mr. Ramchandran thereafter by 1 o'clock. When we rise for lunch, we would have.
Basically.
Can we
Grover.
start now?
Grover, 1 second.
We will take it and.
Let's start now. By 1 o'clock,
Okay.
we would have completed with Dr. Singhvi and Mr. Ramchandran's argument.
Now, your lordship's
I would
PDF.
request, my lord, only 10 minutes of time, my lord, because this court, my lord, is not
tell us
usually it does not
I'll
restrict
tell you one
arguments
thing.
of councils.
Look,
That
we are
is why.
also not ignorant. I've read Mata Nazbom extensively, and I still continue to read Mata. That's why after my day's deed is done in the court, this is what we sit down and read to get some sanity in our mind also at the end of the day.
I'm
For
only,
Mata Nazbom, do you have to keep on interrupting by the minute over here? I'm appearing for a gay activist. I want to show you Mata Nazbom. Of course, just give us a note. We'll read it.
My lords,
indicate-
my
That's a
lords,
matter
I'm
of
also
joy for
caring
us
for
to
one
read.
of
It's
the
a matter of joy
PDF
for us.
1180.
Like Justice Bhatt
PDF
said, you know,
1180 minutes.
I mean,
My
it's
lords-
difficult to tell you. I was factoring that, okay, now summer vacation is going to be on this judgment. We'll have enough time. There's not, you know, the pressure of SLPs is not there. We'll sit down. So give us a note on Martha now.
The written submissions are already there, only to indicate, only to
Point
take your
out,
lordship
just
through
point
that,
out.
only I'm seeking some time. That is,
Out.
after
My
the petitions
lords-
conclude, my lord, there won't be any repetition on from my side.
Somebody will
My
then say, I
lords-
want to now point out Rosalind Dixon. Why just
My
Martha?
lords, I
Somebody
will
say,
seek
I want to
indulgence of
point
my
out
lords
Bruce
only for 2
Ackerman.
minutes, my lords.
All right,
PDF
we'll love to
11.
hear it. I mean, I have just all of it threatening to fall on my head in the night. You know, I've got such a pile of unread books.
PDF page 1180. Let me that's
Yeah.
the one.
Chalo,
Would your lordships continue
PDF
on
page
Monday
1180.
also?
Yeah, we'll start on Monday.
My lord's prerogative, my lord, Monday is a working day, my lord. My lord,
There's also working. No?
no, my lord, it's admission day, my lord. There are several matters, my lord, which are already.
All right, we'll see, solicitor.
But let this start, my lord. On our side, your lordships may give us.
Solicitor, have you ever seen us being unreasonable in the court? Then, just we have to put a little pressure on everybody so that is right. Yeah.
Your lordship would not curtail us, but I'm confident about it.
Your lordship has binary request. One request.
Otherwise, we are
one
answerable
request.
to our
not
own
to us.
conscience, solicitor. We are
Your lordships
never will
would
until
be
we
guided.
feel that we have heard the matter fully. We'll,
Now, Malas, 1180 PDF.
All
I'll
right.
just raise through, Malas.
just 1 second.
What do you want us to open, Doctor?
1180, Malas, PDF, that compilation of last evening.
143 that we will.
I'm grateful. 142 is over, 143 and 144 gets Malas,
Volume.
Baroness Hale over.
Not precedent. Volume 4 foreign. मेरा तो volume 4 है.
Yesterday evening, Baroness Hale, PDF 1180, para 143. Volume compilation 4.
Volume 4 foreign judgments.
Yes, it's actually open.
It follows.
Just a moment, please.
143 you were reading. huh?
Correct.
That's where we stopped yesterday.
Correct, please. May I read?
Yes, please.
Yes.
It follows that a homosexual couple whose relationship is marriage-like in the same way that an unmarried heterosexual couple is marriage-like are indeed an analogous situation. Any difference in treatment is based upon their sexual orientation. It requires an objective justification if it is to comply with Article 14. Whatever the scope for a discretionary area of judgment in these cases may be. This is very beautifully put. It can be transplanted subject to my Lord discretion to this Indian Supreme Court, to our Article 14. Whatever the scope for a discretionary area of judgment in these cases may be, there has to be a legitimate aim before a difference in treatment can be justified. But what could be the legitimate aim of singling out heterosexual couples for more favorable treatment than homosexual couples? It cannot be the protection of the traditional family. The traditional family is not protected by granting people,
43.
which is denied to people who cannot or will not become a traditional family. What is really meant by the protection of the traditional family is the encouragement of people to form traditional families and the discouragement of people from forming others. There are many reasons why it might be legitimate to encourage people to marry and to discourage them from living together without marrying. These reasons might have justified the act in stopping short at marriage. Once it went beyond marriage to unmarried relationships, the aim would have been to encouraging one sort of unmarried relationship and discouraging another. The Act does distinguish between unmarried but marriage-like relationships and more transient liaisons. It is easy to see how that might pursue a legitimate aim, and easier still to see how it might justify singling out the survivor for preferential succession rights. But as Lord Justice Buxton said, it is difficult to see how heterosexuals will be encouraged to form and maintain such marriage-like relationships by the knowledge that the equivalent benefit is being denied to homosexuals. The distinction between heterosexual and homosexual couples might be aimed at discouraging homosexual relationships generally, but that cannot now be regarded as a legitimate aim. It is inconsistent with the right to respect for private life according to everyone, including homosexuals, by Article 8 since Dudgeon's case in 1981. If it is not legitimate to discourage homosexual relationships, it cannot be legitimate to discourage stable, committed, marriage-like homosexual relationships of the sort which qualify the survivor to succeed to the home. Society wants its intimate relationships, particularly but not only if there are children involved, to be stable, responsible, and secure. It is the transient, irresponsible, and insecure relationships which cause us so much concern. Last para to be read. I have used the term marriage-like to describe the sort of relationship which meets the statutory test of living together as husband and wife. As husband and wife. Once upon a time, it might have been difficult to apply those words to a same-sex relationship because both in law and in reality, the roles of the husband and wife were so different and those differences were defined by their genders. That is no longer the case. The law now differentiates between husband and wife in only a very few and unimportant respects. Husband and wives decide for themselves who will go out to work and who will do the homework and childcare. Mostly each does some of each. The roles are interchangeable. There is thus no difficulty in applying the term marriage-like to same-sex relationships. With the greatest respect,
Dr. Singhvi, this was a case where the Act squarely applied to unmarried relationships.
Yes.
And the principle was that if you're unmarried, if the Act applies to unmarried relationships between heterosexuals,
yes,
there is no basis to exclude unmarried relationships among homosexuals.
It is the second last formulation of your lordship sentence which I am concerned about, that when you have a particular paradigm applying to a heterosexual group, your lordship, Malas, absent something very special, will find it discriminatory not to apply it to
others. Baroness Hale uses the expression marriage-like relationships.
Yes.
So these are not marital relationships, marriage-like relationships of heterosexual couples who are in a stable relationship, but who are not married. They said that therefore, if you are extending protection to heterosexual couples who are in a marriage-like relationship and therefore not married, there's no basis to deny it to homosexual couples who have a marriage-like relationship but who are not married.
I'm grateful, Malas. That's one. But Malas, the language of the paras I've read yesterday and today
may be also very, very
of
extension. You're right.
And your lordship is not bound by these judgments. Your lordship will find persuasive value to the extent your lordship finds. Now I turn to that article, Malas, which according to me is one of the most well-written articles on interpretation. On reading down, reading up, what your lordship
which is that article now?
Treaty compliant, or in our case, constitution compliant reading. Constitution compliant reading. Kindly hand over. It's better to use the hard copy. I'll read only 3 sections, a few pages of it. Kindly hand over.
Oh, okay. Sorry, I was just. Thanks.
We also emailed you, but this is better and quicker. The lordship may mark this.
The judgment is done?
That is done. That is over, Malas. Now, kindly come to the first page. What is the year of this? What is the year of this publication? Don't do multiple things. Focus. Year. Just come to the first para, your lordship will ignore. I mean, it's about UK and New Zealand. Second para on the first page. On the first, I'll be making your lordship mark only some portions. It's rather well put, Malas, and it is triggered by, that's the reason I'm citing it. The key question for the courts in applying such directions is how to determine when it is or it is not possible to ascribe a rights-consistent meaning to the legislation. Although a definitive answer to that question has proved unsurprisingly elusive, a shared assumption to date has been that the line that is being drawn, this is the point for this, line that is being drawn between interpretation on the one hand and legislation on the other. The task assumed by the courts is to search for an interpretation of the relevant statutory provision that would bring it into conformity with human rights standards. Now come to page 2, Malas. Beyond the margins of interpretation, however, lies the constitutionally impermissible territory of judicial legislation. And that's your lordship's, Malas, equation. The next parameters, given this characterization as essentially interpretive, it is perhaps unsurprising that I'll skip the New Zealand specific para, come to the third para. In the United Kingdom, however, and this is important, a new model now seems to be emerging. In a series of cases, culminating in the decision of the House of Lords in Ghedan, I just read it, the United Kingdom courts have cast doubt over the centrality of statutory language to the determination of whether a rights-compatible reading of legislation is possible in the right of the Human Rights Treaty. The text is not the law lords have said, determinative. The text is not determinative. Rather, the courts will be constrained only, mark the word only by the underlying thrust of the legislation A and the limits of their institutional capacity. Now, the counter question, the devil's question, is posed in the next paragraph. This paper discusses Ghedan and its implication. It suggests that the remarkable aspect of Ghedan is that it simultaneously divorces the process of statutory interpretation under HRA from the twin anchors of parliamentary intention and statutory text. This I'm relying upon heavily, this first sentence. The second part, in that light, it is suggested that the dichotomy between interpretation and judicial legislation is at the very least under pressure, and the courts are in fact appropriating to themselves a significant, if nevertheless a subsidiary slice of legislative power. Now come to page 8. Page 8. So, where did you write it down? Page 8. Of the 4 law lords in the majority,
Yes.
of the 4, page 8, 8. Big Roman 2. Of the 4 law lords in the majority, the names are given. All but the last delivered a separate opinion on the correct methodology under 3.1. There was, however, substantial agreement on these essential principles. Then the key issue, separating the sheep from the goats. Their lordships identified the key issue under 3.1 as being how to determine the limits of what is possible. The scheme of 3 and 4 of the treaty envisages that there is a Rubicon which the courts may not cross. What is not, however, spelled out is the test to be applied in separating the sheep from the goats. Parliamentary intention is not the touchstone. This is another red herring which your lordship may have to deal with in the present case. In investigating the line between the possible and the impossible, Lord Nicholas and Lord Stein held that the courts were not constrained by the intention of the Parliament that enacted the legislation. Very, very important. Lord Nichols distinguished the required approach in this respect with the orthodox approach to standard statutory interpretation, which involves seeking the intention reasonably to be attributed to Parliament in using the language in question. In contrast, Section 3 may require a departure from that parliamentary intention. The key question being how far and in what circumstances. This is because there is another and a countervailing parliamentary intention which needs to be given full weight. Namely, the intention reasonably to be attributed to Parliament in enacting 3. So it's an objective test being brought in. Objective. Now, nor is the statute. The second thing which is not determinative is statutory text. And it is quite interesting and astonishing, though now in a constitutional context, American English courts are saying this. When we were brought up, it would be sacrilege to suggest this to an English court. Remarkably, their lordships held that the language of the statutory provision at issue is not the touchstone in deciding which it is not possible under 3.1. This holding had a number of dimensions. Further, their lordships expressed concern about excessive concentration in a literal or technical way on the linguistic features of the statute. Rather, Section 3 requires a broad approach, concentrating amongst other things in a purposive way on the importance of the fundamental right involved. So intention one way, statutory text one way. Now we've got a third test, importance of fundamental right involved. Secondly, their lordships stressed that the proposition that ambiguity in the statutory language is not a prerequisite to the operation of 3.1. Ambiguity is not your lordship's poll star. Thirdly, 3.1 might thus have a role even if the statutory language is not capable of bearing 2 meanings. Lord Nichols says, once it is accepted that 3 may require legislation to bear a meaning which departs from the unambiguous meaning the legislation would otherwise bear, it becomes impossible to suppose that Parliament intended that the operation of 3 should depend critically upon the particular form of words adopted by the parliamentary draftsman in the statutory provision under consideration. That would make the application of 3 something of a semantic lottery. From this, the conclusion which seems inescapable is that the mere fact that the language under consideration is inconsistent with a convention-compliant meaning does not of itself make a convention-compliant interpretation under 3 possible. So this is impossible, I'm sorry, impossible. So your lordship's ultimate guide star is intention, no. Text, no. Parliamentary, well, is overall purposive theological, no. But the ability to achieve a convention compliant result. A convention compliant result. Next page, Willis, at page 10, I'll just read the quotation. Fourthly, their lordships considered that 3.1 empowers the court, if necessary, to change the meaning of the legislation. This is actually the heart, the legal heart of this case is this, Willis, interpretation, how to look at these sections. 3 enables language to be interpreted restrictively or expansively, but a 3 goes further than this. It is also apt to require a court to read in words which change the meaning of the enacted legislation so as to make it convention compliant. It is apt to require the courts to read in words which change the meaning of this enacted legislation so as to make it convention compliant. In other words, the intention of Parliament in enacting 3 was that to an extent bounded only by what is possible, a court can modify the meaning and hence the effect of both primary and secondary legislation. Their lordship's view is not the touchstone in determining whether a convention compliant reading of legislation is possible, begs the question. If not the words, then what? How then is one to sort the sheep from the goats? Their lordships identified 2 overlapping limits. So now he's answering the question, how do you separate the sheep and the goats? What is possible under 3.1? This is the first test, fellows. General thrust of the legislation. Second is court's institutional capacity, which is defined later on, coming out later. As to the first, their lordships held, 3.1 does not authorize the courts to adopt a meaning that is inconsistent with what they variously described as fundamental feature of legislation, underlying thrust of legislation, grain of legislation. Each of the footnotes gives the lordship the para. A cardinal principle of legislation, the very core and essence, the pith and substance of the measure. Well, is to take a 5-second aside. It is a kind of a basic features, intra-legislation. Basic structure doctrine, intra-legislation. Right. These are well interesting developments. The lordship is...
The tenor and the provision of the law.
Exactly.
That internal, does it make
internal sense? It has to be intra.
It can't confine it to...
Correct.
Wow.
This notion that the courts cannot turn, page 11, 11 top. This notion that the courts cannot turn the scheme of the legislation inside out overlaps with the second point, which is that the courts cannot make decisions for which they are not institutionally equipped. Now, what is the meaning of this? Some cases that lordships held call out for legislative deliberation. So, if it's a case where a lordship finds the whole script has to be written, it has to go to the legislature. This might be the case, for example, if the exercise of making the legislation convention compliant would involve the substitution of a detailed statutory scheme. It's a very fair test, fellows, very fair test. Or if a policy choice needs to be made between different methods for achieving convention compliance, or if the decision would have far-reaching practical repercussions the courts are not well equipped to evaluate, this has to go case by case, fellows, to your lordship's ultimate decision. Now come to 13, page 13, 1.3. In Ghaidan, however, lower part, second half of the page. In Ghaidan, however, the House of Lords rejects both a focus on text and a focus on purpose. I'm sorry, Justice Kohli doesn't have page 13, lower part. I'm just doing a little bit of speed reading, Your Lordship's permission. Now, Your Lordship, teleological purpose, Bennion. So even that is out. Both a focus on text and a focus on purpose. This creates something of a puzzle as to what their lordships might mean when they say that the interpretive possibilities created by 3 are limited by the underlying thrust, 1, of the legislation. Considered in isolation, that proposition might sound a restatement of the modern purposive approach to statutory interpretation. The purposive approach has, however, been explicitly rejected by their lordships. The intention of Parliament in enacting the legislation must, they said, give way to the intention of Parliament in enacting. That the underlying thrust approach is not consonant with the purposive approach is manifestly evident from their lordships' analysis of the statutory scheme, page 14, top, at issue in Ghaidan itself. Lord Nichols postulated that the social policy underlying the extension of security of tenure in 1988 to survivors of de facto opposite sex relationships was equally applicable to survivors of de facto same sex relationships. On the basis of that essentially normative conclusion, he held that the underlying thrust, this is the test for us, the underlying thrust of the Rent Act of 77 did not preclude a convention compliant interpretation.
So then
The underlying
two parts. One is yes, this is how you make it consistent with the convention. The second is they abandon the purposive construction method.
and the textual and the intention based. Now, if your lordships were to find
Was it? Diametrically.
well, if there's a prohibition, I would say, in fairness, the answer would be no.
Then
If the language is diametrically opposite.
interpret it to
No,
choices
the
of the
lordship
court.
is, when your lordship puts that question, I am answering it saying that diametrically opposite must mean prohibition.
The prohibition, there could be.
Prohibition.
We are looking.
Answer has to be no.
let us- let
I'm
us-
not here, Malus, to suggest your lordship that your lordship has a prohibition and your lordship is then overriding it on the basis of interpretation. Then your lordship may be able to override it for Malus some second argument. It's not the only answer. Second answer is
But if
your lordship
provision-
as not constitutionally compliant. Malus,
when-
there are two ways of looking at this. One is that we challenge it on the ground of unconstitutionality, as we are doing the notice and objection provision to which I have just to turn. Your lordship will then apply that test. The first test, my lord, Justice Narasimha is asking me is intra-legislation. To that, the answer would be if there is a prohibition, and I still ask you to only interpret. Your lordship may have
How
difficulty.
can we confine to that concept that if there is a prohibition, then only we say that it should go back to the legislative drawing board? Because
No, if it's not constitutionally compliant on the larger challenge, no. Your lordship can strike it down.
let me complete. We are focusing our gaze on the only provision. In Gaidan, it was possible. Gaidan, the question was simple. And also, Gaidan was not essentially concerned with matrimony. Essentially, it was concerned with protecting tenants and whatever was the consequence if one of them who was living in a relationship died. So therefore, it was possible to not even go into the internal mechanics of the concerned enactment. Here, perforce, whether you like it or not, we will have to insert ourselves into the mechanics of.
Therefore, Malus, therefore, two things. Ghedan, the underlying, although the issue was Rent Act, the underlying thrust was found by all 5 judges to mean that you cannot discriminate between heterosexual couples versus homosexual couples in the interpretation of that act. Number 2, the question would be if your lordship found that SMA, the underlying thrust, is not this, or the SMA precludes that underlying thrust, then your lordship would go one way. If your lordship, however, to find that the underlying thrust of SMA does not exclude, and that's the heart of the answer to my lord's query, does not preclude or exclude a same-sex couple, that's follows. Therefore, that choice ultimately follows the.
If presented the way Gaidan is presented, we have no difficulty. But if you take the steps in Gaidan, which is the internal sense of the enactment, then we will necessarily have to go into
the two different acts. Lordship, naturally, this is Gaidan is something else. This is something else.
Then
I'm only on the approach.
The route which we may have to take is something else.
Well, I'm only giving your lordships a approach to interpretation,
Yes, you're right.
which should comment to your lordship.
quite
Obviously, in a different context.
It's a very novel approach.
Novel approach and in
But
different
having
context.
said that, here you're really leading us on the path of statutory interpretation.
That's true.
Statutory interpretation, not based on text, not based on intention,
Go beyond.
not based on original intention, not based on purposive teleological
So
interpretation.
you're really asking us to read into the statute the expression spouses for really man and woman.
So does the underlying thrust of SMA exclude your lordship's reading or insertion or understanding of that construct? Is the
Because your principal premise is that when the legislation was enacted in 1954,
yes,
the object of the legislation was to provide a form of matrimony for people who are not falling back on their personal law of marriage.
Absolutely.
Right? And
Special categories.
You are giving Parliament was intending to provide an avenue to people beyond your religious, the religious governance of marriage, so to speak.
There was also an aspect of endogamy.
Yeah.
Yes.
There was
Yes,
an aspect
yes,
of
yes,
endogamy
yes,
which
yes.
we cannot ignore.
Yes, yes, yes.
So
yes.
it was an all-enfolding kind of a legislation.
And it cut across so many spectrum because it was intended to
And
be a very
therefore,
special category.
after 1954, in the last 46 and 69 years, our law has really evolved to recognize the fact when you decriminalize homosexuality, you also realize, well, these are not just one-off relationships. This also comprehends a stable
That's
relationship.
because you go back and
Therefore,
say, yeah.
by decriminalizing homosexuality, we have not just recognized fleeting relationships between consenting adults of the same gender, right? We have also recognized implicitly, therefore, the fact that people who are of the same sex would be in stable relationships. Now, if the object of the law in 1954 was to bring in its fold people who would be governed by a matrimonial relationship apart from their personal law, then surely that law is capable of being broadly read according to you, so as to take into account more stable relationships.
Let me put it
of
bluntly.
the same
I'm very
sex as
grateful.
well.
Let me put it bluntly. When you enacted the law, you did not, in the debate in Parliament, in the writing of the draftsman, when I get up and speak on it, may not have got homosexuals in mind. You may not have considered them.
Way of
That
looking
makes
at
no
it.
difference.
You may
Another
not.
way which you are perhaps propounding is this provided a framework, but that framework is of the concept of marriage. The
Exactly.
concept of marriage transcends contemporary understanding to
It's an evolving,
comprehend-
dynamic concept.
to
Absolutely.
comprehend an evolving idea of
Dynamic,
marriage.
very dynamic concept.
So used in a constitutional sense, it only provides a framework.
Framework.
And that framework is broad enough to, assimilate later developments.
I
It
don't want to.
transcends the existing.
I don't want to sound well. That is really well put with respect. The provision of a framework which departed from the existing framework already, because it took care of personal laws. Now, in that framework, are you cast in stone, or are you in an evolving dynamic picture? And can the underlying thrust and your lordship's institutional capacity sustain it? This is the summary of the whole Ghaidan principle applied to SMA.
And from the perspective of institutional capacity, we have to ask ourselves whether we would be doing something which would be fundamentally contrary to the scheme of the statute.
You also have to make a new statutory scheme.
Yeah, exactly. Would the
New
court be
statutory
rewriting the entirety of the statute? Would the court really be making policy choices which is for the legislature to make? So long as we don't straddle that line which divides policy from the judicial process, you're still within the fold of it.
I'm very grateful, which is why they have put this second test. The
But
first test
equally,
was
I
enough.
think the impact of
Put a
Ghaidan
line.
is to liberate the court
Yes.
from the very, very traditional approach
Yes.
of looking at everything as a matter of statutory interpretation. Therefore, purposive interpretation also falls back on interpretation of that statute and the language of that statute.
That is important, Malas. That teleologic and purposive also, which is supposed to be in
play
advance,
again-
falls back.
I'll play a little bit of a spoiler. Ghaidan provided the framework for the introduction of a law in 2004, which assimilated all these developments, which led to the blessing of statutory recognition of these kind of partnerships. And then it took another 10 years for these to be recognized as marriages. So that too is an aspect which we will have to keep somewhere in mind.
Absolutely, Malas. Your lordship, that's the difference. It's a holistic thing your lordship keeps in mind. Ultimately, the feel of the case is only your lordship will. That is, nobody can be identical. Nobody is saying
Because
it.
I'm sure if you go to Ghaidan and if you follow it up, there could be other cases which have followed
Now,
that.
so I've now, Malas, time, given my
Dr.
time.
Sigby,
I've done this.
Dr. Sigby, I think, looking at India constitutionally and socially as well,
Yes.
we have already reached the intermediate stage, right? The intermediate stage postulates that by decriminalizing homosexuality, your very act of decriminalizing homosexuality does contemplate that therefore people who belong to the same sex would be in stable marriage-like relationships.
Marriage-like is the operative word.
Right, marriage-like relationships.
Live together.
Because the moment we have said that it's no longer an offense under Section 377, therefore we necessarily contemplate that you could have a stable marriage-like relationship between two persons who do not treat these as chance encounters, but as something more than that, not just a physical relationship, but something more of a stable emotional relationship, right?
Societal.
Which now is an incident of our constitutional interpretation. Once we have made that, we have crossed that bridge, then the next question is as to whether our statute can therefore recognize not just marriage-like relationships, but relationships in the relationships
On the
of
contrary,
marriage.
I started by saying it's a logical move in the same direction. It is, in fact, little done, vast undone. Your Lordship is now getting to cover that territory because to merely decriminalize is one category. Otherwise, it does, in an actual daily sense, remain a shell.
Requires us to,
Hollow shell.
requires us to redefine perhaps the evolving notion of marriage, because is the existence of two spouses who belong to a binary gender necessary, or the requirement for a relationship of marriage? Or has our law now progressed sufficiently to contemplate that the existence of binary genders may be, but is not necessary for your definition of marriage?
And Malas, to that comes in the intersection of the Article 14. You in your counter and everywhere else are underlining immeasurably the vital importance of marriage, to which I bow down. But that vital importance of marriage is restricted to one category.
Expanding that definition, are we then trenching upon that area which Gaidan excludes to the judges?
That is, Malas, in case your Lordship has got to stitch a whole cloth, which only a statute can do. That ultimately will be your Lordship's call. I don't think at all, which now, Lordship will just note on the side, para 44 is some other cases similar to Gaidan. I'll not read them. I don't have time to read them. Para 44 of my submissions. I'll now come to that 3 or 4 queries arising under the SMA, and then come to the notice of objections regime.
But in a way, Dr. Singhvi, I think what happened in the UK is really, in that sense, not in that. I was just talking to Justice Kaul, is not really in that sense in all fours with what happened in India.
Not at all.
The HRA in the UK was intended to enforce treaty obligations under the ECHR.
Yes.
Right? For us, we've always had the overarching principles of the Constitution, which lie above.
That's the irony. We are a for sure, Malas, with respect. I'm saying on interpretation. This case is cited and the article is cited only for an approach to interpretation.
And, we are not here using the Constitution or utilizing the text of the Constitution to either read down a statute or to strike down a statute. That's one element of the impact of the Constitution. The other thing which we are doing now here is expanding the meaning of a statute in the context of constitutional guarantees. And in that, you are saying be liberated from the bare text of the Constitution. Or the notion of parliament.
The first part of what I argued yesterday was dignity, non-discrimination.
See, in the backdrop of constitutional interpretation, we have never used the originalist doctrine, right? India, unlike say what Justice Kalia said, we have never regarded ourselves as bound by an originalist interpretation.
Kalia is an extreme example.
In which case, Dr. Singhvi, if we have never been bound by an originalist interpretation of the Constitution, should we be bound by an originalist interpretation of the statute? Which is in that sense subordinate to a constitution.
And he, Their Lordship knows that a court of one. He said, if I'm the only one, I'll always stick to this original intent. Court of one. So, your basic, all that I'm saying is, one, because I've done the constitutional aspect, yes, unless Your Lordship anchors it in the values of 14, 15, 16, 19, 21, that's the first part.
But to put it really bluntly, is the relationship between a man and a woman so fundamental to our law and therefore the Special Marriage Act that for us to comprehend that it will also include a relationship between a same-sex couple would be completely redoing the tapestry of the legislation.
So this
if we say yes, then obviously we cannot.
The underlying agnostic thrust is the underlying agnostic thrust of SMA, antithetical to your Lordship's recognizing what Article 14 normally will always include, namely same-sex persons enjoying the same importance and benefits of marriage as different sex persons. That's the long and short of it. As an aid to interpretation, I've only cited one case which says, and only interpreted statutory out of the Constitution. Does the underlying thrust, alternatively, an interpretation of SMA, prohibit or preclude your Lordship from doing so? Or is your Lordship's institutional capacity so compromised by a particular case that your Lordships cannot do it? That's the fourfold way, connecting yesterday and today.
And really your argument is that, the institution of marriage in itself is so very important that
to
to deny to same-sex couples would be really contrary to fundamental constitutional values.
Sorry to interrupt, my Lord the Chief Justice, but my note yesterday, I said it, para 15 lists 7 important indicia of marriage, and the appendix lists more. Their counter says so. I rely on it heavily. The question is only exclusion. You have it for that side of the table, you don't have it decided. Para 15 of my submissions. My Lord were kind enough to note it down also by hand. Now, without that, if I was to straight away jump into an interpretation exercise of Ghedan, it would be wrong on my part. I'm completing my argument.
Dr. Singh, we're just reminding you it's 12:17.
No,
now, Ghedan is over. This article is done. We've got the trust. Now, what's the next one?
The next. Now, let's very quickly. One, I'll be very pointed. Justice Bhatt put a question to me about Justice Lahoti's order. That's 2005, 3 SCC 313. Don't bother, Malas. Just I'm giving a copy to your lordships. Just note, it was a different case. Justice Bhatt said so yesterday. It's a different case. Context was different. It was, Malas, really about, again, a tenancy law invoked, Malas, by.
This was in the absence of the domestic.
Deserted wife to claim tenancy, etc. But leave that, Malas. Para 1, your lordship will note, the words are evocative. I'm just moving on. Just para 1 of that, Malas.
Dr. Singhvi, what exactly? 2005, 3 SCC?
2005, 3 SCC, 313. Just note para 1. I'll read it fast, Malas. Lordship need not open it. I'll just read it for lordship. Only para 1. The law, it connects with what I'm saying. And therefore, your lordship put this question to me yesterday. The law does not remain static. It does not operate in a vacuum. As social norms and values change, laws too have to be reinterpreted and recast. Law is really a dynamic instrument fashioned by society for the purpose of achieving harmonious adjustment, human relations by elimination of social tension and conflicts. I'll leave it at that, Malas. That's just a. The second thing, Malas, my Lord Justice Bhatt put to me. My Lord, remember that passage, so I've traced it out. That's only. Secondly, my Lords put to me. My Lords put to me.
The contractual relationship.
Yeah.
This is our Gaidan moment in a different context. Our Gaidan.
This is a kind of a Gaidan. I mean, it's a little. Your Lordship is right. That's a tenancy case. But
you see, the interesting part is this predates the domestic violence in Act.
Domestic. That's what your Lordship put to me yesterday. That's the point. That's the point. So static, dynamic, moving. That's the whole point. Second, my Lord put a question which will have to await research. I can't give a Lordship a definite, but what is one of the examples I found? For example, in one narrow case of standard personal accident insurance, what my Lord put to me, is there a statutory regulation? There is by IRDAI, not in the mass of others, but in that, which use the phrase legally wedded spouse. Now, I will make that chart and give it later. I'm not considering, suppose your Lordship were to hold that SMA includes this form of marriage. They would be legally wedded spouse in the sense that your Lordship, after your Lordship's date of may fall within that again. But that is one of the few regulations which has the phrase. The large bulk doesn't. Where that phrase is there, it will depend, Malas, on your Lordship's judgment. But your Lordship's judgment, according to me, even where it finds same-sex persons in marriage valid, would be covered under that. I've given you a specific quote of a particular, Malas, IRDA regulation. The third thing, Malas, is how to apply this gender. The third thing is, just note in bullets, Malas, the answer on this. This is important. Your Lordship has one situation about 2B and the first schedule of the Act. Answer, both parts of both schedules will have to apply to Malad's non-heterosexual couples. The prohibited category yesterday also discussed.
Yes.
Both parts of both schedules will have to apply to non-heterosexual. It does no violence to your lordship's sense of Malad's that your lordship is making a statutory scheme. Nothing. The statutory scheme exists. My lord is not saying whether he and I are prohibited category. Whether he and I are prohibited. Lordship is not defining. Your lordship is saying it will apply on both parts. That's answer number one. No violence to the underlying trust.
Can you say that again? Can you say that? Repeat that.
Yes. The two schedules in question for the issue of prohibited degrees of relationship will apply, both of them simultaneously, to all non-heterosexual couples.
That's what Mr. Rotegi said.
That's right. So we are now ironing out your lordship.
Collapse into one.
Yeah. Suppose your lordship has to make out a prohibited relationship. That would be legislation. Suppose your lordship, I am asking to do something which creates something. Nothing. Your lordship is reading in something and making it harmonious. Second, 4C, age 4 items. One I've done with prohibited degrees. Second is age. There are the 4 questions here, Rose. Age, the simple and the correct solution is, Malas, that whichever of the same-sex couple is involved, that age will apply.
Sorry?
First is
Age.
prohibited degree. I've
That's
mentioned both.
okay.
Second is, Malas, age. Whichever of the same-sex couple is involved, whether it is 2 ladies or 2 men, that age will apply, be it 18 or 21. I'll come to the gradations in a minute. Give me a minute. Without having any stitching to be done on a legislative cloth. Third, now the question may arise, what about trans categories? The trans categories, my your Lordship will hear other people are there. My own humble submission would be, in 99% trans categories, your Lordship is able to slot the person as per the gender which he or she professes, says belongs to, claims, etc. Because a trans means a man's body but inclined to be a woman, or vice versa. So if your Lordship were to then follow that slotting, and if the person is a man, otherwise biologically in say leaning towards the feminine side, then the age of the feminine will apply, or the age of the male will apply, vice versa. The fourth point here is, the fourth point is that your Lordships will keep in mind that I am focusing on what is all these petitioners? They are focusing on the discriminatory parts of the provisions. We are not challenging every provision or interpreting every provision. We are challenging the discriminatory portions of the gendered provisions. Gender provisions which are, so we are not concerned with every provision. And certainly the government of India is not challenging any provision. So your Lordship will see only our challenges or our reconciliations where necessary. Fifthly, some provisions which may not create any confusion, like 27(1)(a) of the SMA, only an example. They are peculiarly, conceptually, designedly created and applicable only to heterosexual relationship. Rape. I mean, you cannot have a system which applies uniformly to every category.
No, why?
Rape.
Why can't it apply to a homosexual couple?
No, with a caveat. Well, it's a criminal offence which has been defined. I will find the shortest definition is non-consensual penile vaginal penetration. It's one simple way of putting it. Now, of course, it has been expanded after the Verma committee to mean other forms of but otherwise non-consensual penile vaginal interface. Penetrative. Now, it is true that as well as rape, apparently rape is a crime even by a woman or a man in France, as far as I know. Those are special cases. Today, your Lordship's issue is, can your Lordship not move forward by these kind of possible obstructions?
Then we admit that in this case it will apply to one kind of one kind of same-sex partner. This marriage offense,
yes,
it's a marriage offense, will apply to one kind of same-sex partner.
It is possible. I'm only saying it differently because it's a crime. According to me, it will be covered in a penetrative same-sex situation also.
No.
But it's a crime. A crime would have to be.
We are talking of outside of the marriage relationship. When you indulge in that, that's a matrimonial offense, entitling the other spouse.
No, it will be only if a Lordship holds this marriage. Lordship will have to hold this category of unions to be a marriage first.
That's right.
Then the question will arise.
Testing.
Yes.
We're testing that if
yes, correct.
Then it will apply to one class of same-sex.
No, therefore, there are two ways. I mean, I concede there are two ways. One is that if your Lordship holds this class to be covered, then your Lordship would have 27 applying to penetrative assaults.
Then we have in this.
No, even for the same sex. Even for the same sex. That's the logical conclusion. Alternatively, your Lordships could draw a line saying it's a criminal offense which has been defined in a heterosexual context. These are the two options. I can't say more.
Then we have three categories, really speaking. We accept the first option which you are offering, which is that A, it applies to the male.
If it otherwise satisfies the definition.
But it will not apply. So there are three meanings to the same enactment.
Is from moving ahead.
No, it applies
These are
to the extent it applies.
There are some peculiarities.
In a heterosexual relationship,
Yes.
Say there can be possibility of reading a rape into it, then how can in a homosexual relationship it not be read?
Not be read.
Well, I'm saying in fairness, I started by saying that. Well, in logic, no. In logic, no.
Can your lordship
There's a conundrum.
use the mic, please?
I thought I said in a heterosexual relationship, if in case of a married
Logically,
couple,
no. Correct.
there can be rape, then how is it possible that we don't have a scenario where in a homosexual relationship the same principle will apply? The same principle.
So, Malas, if your lordships were to, Malas, apply the definition of non-consensual penetrative sex, Malas, then it would apply. Logically, that's the correct answer. With great respect.
That's the little trouble of seeing how we get into different sections, how we get into different laws,
Right.
how we get into it. So the debate would be whether we stop just short of saying, you are saying it may be empty shell, but should we stop short? I'm just thinking
No,
now.
no, Malas,
of
may
just
I
saying-
answer it? May I answer it?
Just saying that this is under this act, such a marriage is possible and registered. Thereafter, there may be many, many nuances which will arise.
No, there is.
Can we take care of all future eventualities?
No, Malas, there is one flip side to it. There is one flip side to it. Malas, there is a flip side to it. I'm sorry, I've not completed yet. Malas, this is important. I'm not completed. Malas, marital rape is not recognized yet in this country.
That's right.
Marital rape, that's the fourth.
That's an issue pending.
That's the issue pending. Today, the law is not marital rape, Malas.
No.
Therefore, once your lordships were to read marriage,
There are people who are wanting us to move in that direction also.
There are
Wanting
matters
us to move in a
pending.
different direction.
that's a different, Malas.
Not
No,
matters
no,
pending.
that's a different debate.
Marital rape too.
Today, as of today, rape, there is, Malas, it's not a recognized crime within marriage. It's maybe a ground for divorce or some cruelty. Cruelty is a better way of putting it. But now my point is different. My point is different, Malas.
The High Court judgment-
Karnataka High Court
Karnataka
judgment.
Court.
that covers-
That's an outlier in the sense that your lordship is still debated. It's not a law of the land.
This court has not taken a view on it.
You view it,
There
yes.
was a-
There's
But I'm on a different point.
a view.
If your lordships, this bench were to recognize the issue we are canvassing, within the marriage which your lordship recognizes between same-sex persons under SMA, your lordship would be recognizing, Malas, marriage within this act.
All I said was that whatever flows from a relationship, a law which will evolve on a heterosexual relationship would equally apply to a homosexual relationship. That's the point I was trying to make.
Very well. I leave it at that.
Dr. Singhvi, the other would be, and we are open to it, we are only putting a question, would we like to go that step further to go into these nitty-gritties? Because there are several shades on the palette.
No, but this is important. The first four answer is yes, your lordships can easily iron out. Now, my point is, I am not raising them. These are, I am answering, put your lordship as an insuperable obstacle. To your lordships to proceed. There are, but these things will happen. These will be ironed out in the goodness and fullness of time.
Noted your argument.
That's all I'm saying. I'm not raising it, Malas.
This is a flag
I'm in
that-
repulsion on this.
Stopping short of many things is just an empty shell.
Right.
If we agree with you.
If we start.
Now, Malas, a few words and I'm done on notice and objections. The very important part. This is very interesting. Malas, notice and objections. We are one of the few petitions where we have challenged it.
Will be in very
Go
serious
back to
trouble
your
there.
written compiler.
objections regime. Very interesting, Malas, and very pointed. Malas, I will not read sections 5 to 9. And thereby save time. Your Lordship knows 5 to 9 well, Malas. Just note one thing.
Which para are you reading?
Malas, it is dealt with in para 47 onwards of my note, which is page 442 of your Lordship's PDF. Now, let me oralize in point formulas. First, your Lordship has got, Malas, Parsi marriages, Christian marriages, so many other different kinds of marriages. No other requires a notice of prior intent to marry. I'm saying something very different. Allow me to develop this point, Malas. This is, Malas, peculiar to the SMA, that before I intend to marry you, I must declare this intent publicly and wait. Number two, and there are all the other provisions of conspicuous place and all that you also don't notice, and newspaper and all that stuff. Forget that. 5 to 9. Point number 2. At the constitutional level, Malas,
This is probably a throwback from the English era. You
to-
put out the bans.
completely English, Malas.
Invite objections.
Well, it's reducing it almost to a sale of a house or a civil suit dispute. But anyway, that's a different issue. Malas. Let me, Malas, say what I'm saying.
Look, this is a different issue. We have not filed a reply. This is tagged.
That's all right.
But
It's
this
legal
is
issue.
entirely a different issue than the same-sex marriage.
It's
This
a-
applies
it's a-
to even heterosexuals, etc.
Yes, of course.
So that
It's
he
a
may
pure
not.
legal issue.
No, Malas,
It's a pure
please.
legal issue.
So that he may not address. Well, there the arguments.
My
will be
learned friend
different.
has filed a reply. It is a constitutional issue. He has
No,
filed a reply. And it's Malas, can I just, in the middle of
Yes,
my
yes.
argument, allow me
Yes,
to complete?
yes, Dr. Singh.
Now, Malas, what's the constitutional issue I'm making? It's a very interesting one, Malas. This part is unconstitutional because before a formal entry into what I consider a vital form of society, marriage, you are invading my privacy by directing me that I must declare my intention in public domain for objections to be invited. Malas, which married couple, Malas, he and I are marrying in the heterosexual sense. When do we have to announce first to the world that we intend to marry and we are waiting for 1 month? In the heterosexual world. Forget heterosexual, Malas, in personal marriages, Malas, under Christian Act, under Parsi Act, under other acts. Why should I say, why should I? It's my personal decisional autonomy. It's my decisional autonomy. It's the heart of my privacy. It's the heart of my privacy to decide with whom I associate, when, how, after how much time, into matrimonial, Malas, union. Be it of the same sex or the heterosexual sex. Malas, it's taken, as my Lord put it, as
Post
a
marriage, there can be a registration.
Now, the next point. That's the next point.
Dr. Singhi, was this clause section there in 1872 Act, which is repealed now?
I'll just check it. I believe it was. I believe it was. 99% it was. It was. And Malas, I'm grateful because it's really a direct hangover from that Raj situation. But Malas, your Lordship are nowhere near privacy and all the 9-judge judgment and Puttu Swami and the dynamic. We have now a totally different world, Malas. Now,
It's based on patriarchy. It's based on patriarchy.
patriarchy. Now, that's now the third point. Your Lordship has in this act, as in other acts, a section 4, which says that you cannot marry if you are related, if your age is below 18. What are those conditions of marriage? My Lord has exact counterpart provisions in Christian Act and Malas Parsi Act. Conditions of marriage. My third point is, Malas, if you have conditions of marriage and you are requiring an affidavit to be filed that I satisfy all these conditions of marriage, the form is given. And if those conditions are found false, either spouse or even the outside world can challenge and get voidness or voidableness, as the case may be, then what is the purpose served with this prior objection, Malas? So now I'm on purpose, on just common sense. After 1 month, suppose I don't give a notice, I marry. After 1 month, Malas, everybody settle down. After 2 months, somebody said that these conditions are not satisfied.
No, who can? Who can approach the court then?
No, but Malas, even after, anybody can approach, Malas.
Who has locus in a matrimonial?
Aggrieved
In a
spouse
matrimonial.
In a matrimonial, yes.
Only a spouse.
Only a
It cannot
spouse.
be a third
Spouse.
party.
Like bigger-
Correct, spouse.
Like a-
No, but I'm saying, Malas, if there is a fraud, If there is a fraud of a gigantic nature today, my lord is right. For variety of things, only the spouse can.
These are
Yeah,
material,
Now-
aberrations or
Yeah,
offenses which only the spouse is entitled.
Now, the point is, that's correct. That's correct. That's correct.
Absolutely.
That's correct. Now, my point is, I am at the moment, what are you serving by this 5 to 9? Now comes the fourth point. I'll tell Lordship what you are serving. In actual practice, in reality, even in heterosexual marriages. Now let us forget same-sex persons. That's the fourth aspect. I have shown that this should be unconstitutional. It serves no purpose. But what is the purpose it is serving for the last several decades? It is serving, the word your Lordship, one of your Lordship just now used, patriarchy. Patriarchy includes matriarchy also.
It was created at a time when women did not have agency.
Patriarchy includes matriarchy also. There are some agonizing
Women
cases.
never had agency. Women did not have agency when these laws and these.
This is an invitation to disaster and violence. It's an invitation. Come.
And if the object was to protect
My spouse has no problem, but you
fall
please
back
come.
on their personal law,
Yes.
then by requiring, you're virtually laying them open to invasion by society, by
My spouse,
collectors and district magistrates and superintendents of police.
my spouse can challenge me anytime. But no, you please from the outside come here. Your Khap Panchayat will come here. Somebody will come in different form. Where is gunning for you? That is not possible. What is the point of all this? In the High Court, the Lordship have sat here and there, must have handled enough habeas corpus matters, coming to your Lordships. Why do they come?
I think in one of the cases, I remember having said that this cannot be given. It will destroy the entire purpose of marriage.
We have the case in our written submission, we'll point out.
Then, the other aspect it hits is choice. Individual decisional autonomy, privacy, individual dignity. This can all be put together, These are all constitutional core values.
Of course.
Interest. What is that supervening interest? I have not been able to find out till now. There is no supervening interest here. Some very great, unknown, mysterious interest. Now, to very quickly come. Some of it has been also read.
198 of the
.47 to 56 of my note is what I've just finished oralizing. Now turn to 58. Yes. 2 minutes. At one place it is there. Yes. I'm sorry, 56. 47 to 55 I have finished just now. Come to 56. Yes. These cases, your Lordship may see at your leisure, are important. Just note the principle. Yes. Intimate decisions from non-consensual public scrutiny is para 56. I hope my lords have got it.
Yes. Yes.
And in particular, marriage is dealt with by Your Lordship Puttu Swami in that para given there. I've given all the paras 271, 297 specifically. Then, the right to privacy is not limited to private spaces but public spaces. It's been read, District Registrar need not be read. Navtej has been read fully, but just note the point. Then public-private divide is 58, fully covered already. That Mr. Rodgi did, leave it, leave it. There is an important phrase I've used, in 61, right to informational self-determination. That's Puttu Swami, para 248. Puttu Swami, para 248, right to informational self-determination. This notice and objection regime is directly the heart of it, And then, decisional autonomy is 65. That's the social context, including all the invitations to disaster. Well, 67 is an important legal principle of proportionality. Kindly give me 30 seconds on 67. This honorable court has recognized the possibility of a systematic abuse of rights infringing measures and read that into an assessment of such a measure's constitutionality under the doctrine of proportionality. This is excessive. This is completely disproportionate. What is the need for this in proportion, Your Lordships, said in Gujarat Majdoor, state action thus leaves sufficient room for abuse, thereby acting as a threat against free exercise of fundamental rights, ought to necessarily be factored in the delicate balancing act the judiciary directly applies. Your Lordship is inviting by this objections regime. And then, equality I've dealt with, in para 72. It's a discriminatory regime. Discriminatory because only if you choose the SMA, and if Your Lordship were to strike it down, please don't misunderstand, it's not to be struck down for same sex only, it's to be struck down per se, for heterosexual and non-heterosexual. It, is the only act. Personal law acts don't have it. This is a direct Article 14, And I have given in para 80 a rather pithy summary of proportionality. 5-pronged test, my Lord remembers. My Lord, I've called it out, 5-pronged test is a legitimate state object, a rational nexus between rights infringing measures, that is the suitability test, para 80. The rights measure should be least restrictive, that is the necessity test. Proportionality stricto sensu, that is balance between the extent and severity of the infringement and the object the state seeks to achieve, and sufficient safeguards against abuse. It stops at B itself. If you add C, D, E, it is completely violative.
In my last week's judgment in Media One, I've sort of developed on the proportionality doctrine, which Justice Sikri evolved in modern day.
Modern proportionality.
And in Media One, we have tried to sort of further fine-tune it.
Least intrusive.
Least intrusive. Well, as I am done, I'm very grateful. One page at the end of some stirring words, which Your Lordship may or may not want to use. Just give it over. This is really the heart of this matter. Ultimately, it's a larger matter than merely provisions. Is this correctly typed? Well, as I've given it in a bit of a hurry with some, I hope there are some typos. Just see these 4 quotations very quickly. One is this one. No, ये तो नहीं है ना. Have you given it there?
Yeah.
Well, you Lordship will leave aside the top, what we are seeking. Just leave aside the top. Come to the quotations. Why do you add without asking me? Well, Oberfell and Hodges, it would misunderstand these men and women to say they disrespect the idea of marriage. Their plea is that they do respect it so deeply that they seek to find its fulfillment for themselves. These are the category like us who has said that why should you be entitled to marriage? Their hope is not to be condemned to live in loneliness, excluded from one of the civilization's oldest institutions. They ask for equal dignity in the eyes of law. The Constitution grants them that right. Whereas Oscar Wilde was a declared homosexual in an era when this was something very, very different. And he died, he was actually imprisoned for it. He fell seriously ill. And then he came out and he died. He put this, an alien tears will fill for him pity's long broken urn. For his mourners will be outcast men, and outcasts always mourn. He was talking in the context of men, Malas. And then, Malas, this is lastly, I have filed these cases. There is a case called Fitzpatrick.
Yes.
The House of Lords is, Malas, the final order. The dissent is what I've quoted in the Court of Appeal. This dissent was approved by the House of Lords. In a reverse. I have come to a clear
Thank you,
conclusion.
Dr. Singhvi.
I'm very deeply obliged. I'm very deeply obliged.
In fact, filed a suit for defamation and lost on this ground.
Yes. Just 1 second. Sorry, I'm reading this one.
I'm very deeply obliged.
We begin with the hearing. We begin with Mr. Raju Ramchandran. And by the end of the day, we would have completed with the submissions of Mr. Raju Ramchandran, Mr. Vishwanathan, Mr. Uttara, and Mr. Anand Grover. We take it, 4 of you would complete by the end of the day. Thank you.
Check, mic check, sound. Check, mic check, check, mic check. Check, mic check. Check, audio checks. Check. Check, sound check. 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 Mic check, sound check.
Anything but mentioning, ma'am, at 2 o'clock. Yes, yes, Mr. Ramchandran.
Wait, please, Your Lordships. My Lords, the last session closed
Yes.
with Dr. Singhvi reading out some stirring words. It is appropriate, my Lords, in the context of the slightly different perspective which I am presenting, to read out some more stirring words of this Honorable Court. Way back, my Lords, in 1956, the iconic Justice Vivian Bose said, the Constitution also exists for the common man, for the poor and the humble, for those who have businesses at stake, for the butcher, the baker, and the candlestick maker.
He said, yes.
Then, my Lords, in 1982, one Randhir Singh, a constable driver of the Delhi police, came before this honorable court asking for equal pay for equal work. And the first paragraph of another master, my Lords, Justice Chinnappa Reddy, is stirring again. Because the judge says, true, he is the merest microbe in the mighty organism of the state, a little clog in a giant wheel. But the glory of our constitution is that it enables him to directly approach the highest court in the land for redress. It is a matter of no little pride and satisfaction to us that he has done so.
That he has done.
That he has done so. Then further, my Lords, I won't read. And it is in this context that it's important for me to state who the two petitioners I am representing are. Petitioner number one Kajal, is a Dalit woman from the town of Muktsar in Punjab. And her partner, petitioner number two, Bhavna, is an OBC from Bahadurgarh, Haryana. Bhavna works as an accountant in a company in Chandigarh, and Kajal works as an assistant in a bakery in Chandigarh. She is the baker whom Justice Vivian Bose had in mind. And therefore, the very presence of these two petitioners and similar petitioners like Ms. Grover's client should put paid bullets to the glib assumption made in the government's affidavit that they are urban elite. That statement, with respect, bullets, was careless, unnecessary, and with respect, insensitive, bullets. And the reason for stressing the background of these petitioners and the nameless others who might be like them is to say that the institution of marriage is not just the gateway to various socio-economic rights, which my two predecessors have sufficiently focused on, but it is a societal protection from their own natal parental families. Such couples don't have enlightened parents. They don't have understanding families. The two petitioners before your lordships had to move the Delhi High Court for protection orders. Those orders are on record as part of my written submissions. And therefore, the point which I wish to emphasize is that the recognition of their marriage is an important protection to them. A societal recognition which protects them from society and from their own parental families in given cases. Now, having offered that overarching perspective, minutes, I am dealing with the matter under just 4 or 5 heads, which I'll quickly enumerate. One is
I am offering another interpretation of section 4, which should fortify the interpretation which Dr. Singhvi gave for reasons which were not articulated in the manner in which
So first is
I wish to.
interpretation of section 4.
Lordship, please. Secondly, Milords, there is another aspect of both 1421 and also 25 freedom of conscience, which I will briefly touch upon. Third, Milords, is the aspect of notice, where the submissions made will be fortified with reference to the historical background. A little background is necessary, which we have set out, and I'll just briefly draw attention to that as to how and in what context these notice provisions came into being and how they are so utterly out of place in today's context. And lastly, a point which I mentioned briefly in an intervention yesterday. For people like us, any judgment of this honorable court, assuming we succeed, will be incomplete unless, as we have prayed, a protocol is put into place on the lines of the Shakti Vahini protocol, which your lordships laid down in the case of heterosexual couples seeking protection from what was called Khap Panchayats. A similar protocol, Milords, is imperative. So may I, Milords, quickly proceed on these lines first. Kindly turn to section 4. Yes, Milords. Notwithstanding anything contained in any other law for the time being in force relating to the solemnization of marriages, a marriage between any two persons, so here persons, may be solemnized under this act if at the time of the marriage the following conditions are fulfilled, namely, neither party has a spouse living, neither party is incapable of giving valid consent, etc. And then, for the first time, come the mention of male and female. The male has completed the age of 21 and the female the age of 18 years.
Right.
Kindly note that the words male and female are not suffixed with the word partner or with the word party. Therefore, without in any manner intending to contend that the kind of union which we are asking for recognition for was contemplated at this act, my endeavor is to point out that the language of this act enacted in 54 itself, without your lordships having to do violence to language, is capable of accommodating situations like ours, because if it is a male union, or a male transgender male union, or two transgender male unions.
Come again. If it's a male union,
or a male transgender, a trans man, let's say, male trans man union, or a trans man union, then 21 will then refer to them. Correspondingly, 18 will be attracted to a female a female trans woman, a trans woman, and that can also accommodate 1/4 category, which is transgender person. That could be read into 18.
Have you articulated it in your written submission?
Lordship, please.
You have?
We have.
Can you
We
tell
have
me?
minutes. Page 690 onwards are our written submissions.
Yes, we have it.
So 18 will apply to female. 18 will apply to female.
Female and female trans woman and trans woman.
So we can use, according to you, one can import the Transgenders Protection Act.
Lordship, please.
Let's see those definitions.
Lordship, please.
Trans man, trans woman.
Yeah. Trans man, trans woman.
You are talking of two categories.
Lordship.
Trans man and trans woman.
Lordship. This approach, if adopted by this honorable court, will not be doing any manner
But then
of
there could be certain categories left out.
Lordship, please. Lordship, please, minutes. But a trans man could still broadly identify with male. That's a sacrifice, a descriptional sacrifice which person seeking the protection of this institution would also have to make.
Right.
There are people who may feel they don't want to be compelled to identify by a particular gender. But if you seek the protection of this institution under this act, that's an accommodation. They will have to come those few steps forward. What the lack of logic which will still remain will be the 18 and 21, which we will just have 2 minutes with respect swallow, for the reason that the very age differential which the law prescribes
is subject to a challenge.
Lordship, please. It is subject to a challenge. It is rooted, milords, in the traditional perception, a patriarchal perception, where the male is the bread earner, the provider, must be old enough to earn, and the female is the child bearer, and she is fertile at 18. That is the archaic logic behind this age differential. That can't be.
There's a bill which is being considered for equalizing the age.
Lordship, please. Lordship, please. So for the moment, we'll learn to live with this lack of logic here, milords, as long as it can be accommodated, milords, within these 2 categories. Having made that submission, milords, may I proceed to the next, milords? Now, milords, when it comes to Article 14, just one additional point in the context of what Justice Kohli had put to Dr. Singhvi yesterday. Justice Kohli's question was, is it a restriction or a lack of recognition? To which the respectful answer is, it is a lack of recognition, and that lack of recognition leads to the denial of the equal protection of laws within meaning of Article 14, and NALSA para 62, which is set out in my written submission, specifically deals with that. Therefore, the lack of protection is sufficient to create a situation of unconstitutionality,
which can be avoided by reading this act.
An appropriate reading of this act. Then, milords, facets of 21, which further need to be highlighted, are 2. My right to health would include my right to have appropriate medical decisions taken for me by the person whom I love, and so often in such situations, there's an alienation. Again, we are not talking about urban families. There's an alienation from the parental family. And so in such a case, in the event of sickness, the individual is left without a person who can take responsible medical decisions, who can sign the hospital consent form, the ICU form, whatever.
No caregiver.
Lordship, please, no
legal caregiver.
No legal caregiver.
That's the 21 argument.
Lordship, please. And there's one more facet of the 21
Yes.
argument. And it is this. If I am gay or lesbian or any of the other categories, then my health and happiness depend on a fulfilling union with a person of my choice.
Yes, this has been covered.
This has been covered.
Lordship, please.
The right
And
to
it's an aspect of mental health. It's an aspect of mental health if I am prevented from.
The point
That's
of
all right.
happiness includes wellness.
Lordship, please. Lordship, please.
The fullness of one's life.
Lordship, please.
In fact, there's a whole segment in my judgment in Navtej which deals with the right to health, the right to mental health.
Lordship, please. Lordship, please. And my lords, 25, I will only state it. And 21 also would include the right to found a family, Wills. The right to found a family, the Yogyakata principles, we have set them out here.
Yes.
Those would also be part of my right under 21. The right to marry. If I have a right to marry, then I have a right to found a family.
Yes.
And 25, freedom of conscience. I have a right to my own moral compass. Having made these submissions, Willards, I will come to the main area where I need to take my lords in a little detail within the time allotted.
Notice, aspect of notice.
Aspect of notice, my lords.
Fair enough.
Absolutely. Now, my lords, the legislative history of the Special Marriage Act, my lords, is set out from page 695 onwards of my written submission. Page 698 of the PDF. Page 698.
Why didn't you tell us orally so that we'll be going through your submission?
Lordship, please. I'm not going to read.
Give us a broad perspective.
Yes, broad perspective is, originally, there was no codified law of marriage in India. It was all customary and religious. Then, during the time of the British, a need was felt for a law of marriage for the British in India. And so that's how legislation came. So that those provisions contemplated marriage only among Christians.
Yes.
Then comes Keshav Chandra Sen and the Brahmo Samaj. And their demand for a secular law of marriage for the Brahmos to be able to marry in, though they did not mind calling themselves Hindus. But the law at that stage, and the chronology is there, required parties to renounce their respective religions. Not being a Hindu, that was a prerequisite. Only to save time that I'm not taking my lords through the language, it's all there, words. That changes in 1923. After which you are no longer required to renounce your religion. But there is a severance of the joint Hindu family status. Which continues, that severance.
The Special Marriage Act.
In the Special Marriage Act in 54. And is ultimately undone.
In 1976.
In 1976. So that is as far as the law of marriage is concerned. And now let's we come to the history of notice in the context of these very laws. And what your lordships would find surprising is that they originate in a 1753 Act of the British Parliament, whose name speaks for itself. It is an act for the better preventing of clandestine marriages. 1753. So then, so therefore, a provision which originates in a preventive statute now continues through the Special Marriage Act, which self-confessedly is an enabling statute. But there these provisions are imported.
Part of your written submissions is covered.
Lordship, please, Lords. Kindly, Lords, PDF 725. That will come to. And Lords, at same page 726, Lords, para 98, there is a table which has been set out giving the history of the notice provisions. And this 30 days notice is the longest ever. If you go to 1753 Act, it was 3 Sundays.
3 Sundays.
3 Sundays. Because weddings were in church. Maybe that was the significance of Sundays.
Yeah.
So the effect is to defer your right to get married at a time when you desire to.
I'm grateful, Mulot.
And it can't be regarded as procedural because the impact is on your substantive right to get married at the time that you choose.
I'm obliged, Mulot. My Lord, the Chief Justice has summed up my argument on this. My submission is that this notice requirement amounts to the requirement of giving a notice for exercise of a fundamental right. If my fundamental right to marry is read into 21, then I can't be asked to give notice of the exercise of my fundamental rights at a future date in the context of a notice regime which is designed by the sheer length. As my Lord the Chief Justice pertinently observed, Millards, a procedural notice is different. If you say 2 or 3 days notice so that the registrar who's in some other town at least is performing other duties, keeps this day aside for registration of marriages. So that's a different kind of a notice from a 30-day notice which is designed to enable parental families and other busybodies to create roadblocks. And my Lord Justice Ravindra Bhatt, sitting as a single judge in the Delhi High Court, had to deal with such a situation in a case whose reference I have given, where the enthusiastic marriage registrar not only sent the notice to the parent jurisdiction, because if you move out, you elope, let us say, just to use a loose word, you go and settle in another district, 30 days domicile there. If you register in the new domicile district, notice has to go to your old district, your permanent district. But the enthusiastic registrars also sent it to their addresses, to their families. So the judgment of the Delhi High Court, to which I am making references, the obligation is only to paste a notice, put it up on your notice board, not to inform families. And that judgment refers to the deleterious effect otherwise of this having on the freedom of choice of parties.
And if the purpose is to ensure that people do not enter into a marriage which will suffer from being void, then this is not the least this is not the least restrictive means which the proportionality test requires us to adopt.
Lordship, please.
To ensure that purpose.
Lordship, please. Lordship, please. And especially when there is adequate provision in every law, if in the Hindu Marriage Act, a marriage within prohibited degrees is entered into, the Act provides. This Act provides for penalties and punishment for making a false declaration. So it is not that people in prohibited degrees of relationship will go scot-free. But you can't postpone. And in situations like this, which we are facing, the postponement creates the possibility, the real possibility of families intervening and putting an end to the relationship. And therefore, this notice period.
Also, Mr. Ramchandran, there is a very real likelihood and not just a remote possibility that this will disproportionately affect situations in which one of the spouses either belongs to a marginalized community or a minority.
Lordship, please.
So it has a disproportionate impact on those who are the most vulnerable segments of our society.
Lordship, please, words. Lordship, please, words. Lordship, please, words. And this requirement of 30 days domicile, one is the notice per se, but the 30 days domicile before you give your notice. So a runaway couple has to choose a new abode, and before getting married, kindly see the problems they run into. They are not married. Which landlord will give premises on rent for those 30 days or 60 days or for however long they want to stay? Where are they going to stay in that new place of domicile?
Mr. Ramachandran, this would be equally true for heterosexual couples who propose to have.
Lordship, please, it should be struck down for all.
Applies.
Lordship, please, it should be struck down for all. It is a totally retrograde provision today.
As long as you prove that you're adults.
Lordship, please, it is both retrograde and obnoxious.
Now you
to require this notice.
So your Aadhaar card, no? Identity will carry out the date of birth.
And if I am correct in this submission, then what are the main provisions which need to go and what are the consequential provisions which need to go? I'm just setting out, just reading out those words.
Main provision.
5 to 8 will be the main provisions. Whose striking down we have specifically challenged.
5 to 8.
But the consequential 7 to 8 minutes. Yes. The consequential provisions or the provisions in aid which need to go would be 9, that is powers of inquiry given to the marriage officer, 10 procedure on receipt of objection by marriage officer abroad, then minutes 14 new notice when marriage not solemnized within 3 months. So for some reason you can't solemnize, and perhaps it's not solemnized because parents have kidnapped. So when they finally get together again, another notice, then another notice. And minutes, finally, the provision which needs to go consequentially would be 46.
46 क्या है?
You said 5 to 10, right?
5 to 8, then minutes 9.
10, 5 to 10.
And then 10. Yes,
On
minutes
the
5
marriage
to 10
officer. On the marriage officer.
Yes, minutes. Lordship, please. I'm grateful.
40.
Then 14 also I had mentioned minutes, but just note to 14. And then 46.
The penalty.
Yes, minutes. Penalty for wrongful action of the marriage officer. Because if this notice provision goes, one of the things he's penalized for is...
All right. So we're done with item 3 now. What is point number 4?
Now, minutes. Point number 4 comes straight to my last point, which is the need for the protocol. So families, couples on the run from their parental families need protection of the state through the aegis of this court. Because on the same S. Rangarajan versus Jagjeevan Ram principle, which is taken by your lordships through various judgments, if the state has the duty to ensure protection of fundamental rights, then such a protocol is necessary. I respectfully commend to your lordships the Shakti Vahini protocol, where minutes in a parallel situation, only thing is the couples were heterosexuals. Those were community panchayats, Khap panchayats. And detailed directions have been given in para 55 onwards of the judgment of Shakti Vahini. I did not read out.
Equally, we have to be careful that in the guise of the protocol, we do not empower these officers who come into possession of information to then use informal methods of suborning the couple. That's also one thing, a danger which we have to avoid. But there has to be a protocol to protect.
Lordship, please.
Protection is sought.
Lordship, please.
Yeah.
That's right. My submissions.
Thank you very much.
I'm grateful, Bullets. I haven't exceeded the
I must
time.
compliment you for such precision and absolute focus. Thank you very much.
I'm deeply grateful, Bullets. And my gratitude to my team also, Bullets, for that.
But I appear in transferred case 12 of 2023, Zainab Patel versus Union of India. Your Lordship may, my Lord, for the time being, not take the note originally filed because coming as I do in the middle order, I had one distinct advantage, my lord, to follow the deliberations, particularly the queries of your lordship, the responses of the union, and the note submitted today, my lord, encompasses and tries to answer some or all of the questions that your lordships have posed, my lord, and my learned friends preceding me, my lord, who have done a very able job, have raised in the matter, my lord.
So, Mr. Vishwanathan, if you could just assist us with the formulation.
I will just formulate it, my lord. Just give me, I have, my lord, a written note with an index, but I just want to give your lordship a prefatory note. I'll take 3 minutes of my own time on that, my lord. My lord, at the bottom of all these constitutional questions, which I have set out and answered, is the one plea of the petitioners before your lordships here. And to simplify it, it is just this, that if we can be, my lord, sons, daughters, brothers, sisters, brothers-in-law, sisters-in-law, uncles, aunts, friends, and partners after your lordship's judgment, what is it that holds back from giving us that status of a married spouse, which we, my lord, acquire and seek to acquire for ourselves, and seek recognition from the union, which union has, my lord, wholeheartedly provided it for the heterosexual couples? The only answer is your sexual orientation, which is, my lord, beyond my control, and the fact that marriage as an institution, as they and the majority of the heterosexuals understand, does not comport with your practices, your requirements. Hence, we would not admit you to the institution of marriage and accord you the privileges which we wholeheartedly, willingly, by enacting a legislation, accorded, my lord, to heterosexual couples. Does that have constitutional sanction? The second answer they give is, by your very nature, you cannot procreate. If so, my lord, I have dealt with in my note, is procreation a valid defense for negating, my lord, the rights of recognition of marriage? And my lord, if we ponder deeply, which has been developed in the note,
Thanks.
which has been developed, my lord, procreation or inability, my lord, to procreate is no answer. None of the marriage statutes, my lord, prescribe any upper limit for marriage. Even today, people who are, my lord, beyond the age of, my lord, reproductive capacity, women beyond 45 who medically may be unsafe for pregnancy are allowed to marry. There is nothing obnoxious about it. People who have decided not to have children, who cannot have children, heterosexual couples, are allowed to marry. Well, these are well settled. So, my lord, procreation is no answer. Then, my lord, does it not bring back the arguments of the miscegenation statutes, my lord, of which I have made reference? Arguments are very similar. The judgments before Loving versus Virginia, the holdings are very similar, my lord. Even the trial court holding in Loving was on the basis that it doesn't accord with our religious beliefs and the common notions of marriage. So we won't permit you to marry. But Loving said no. Because, my lord, it said you cannot understand marriage with any traditional notion that you may have. The other fallacy in the argument, my lord, is again relatable to a historical fact. My lord, these are moments in history, my lord, which we are passing. Similar instances have happened before. All that the union is saying is, everything else is fine. All other relationships are fine. You are almost equal, but you are separate. This is exactly, my lord, what was the stand in Plessy versus Ferguson.
Exactly.
I have placed passages from Plessy, except that there it was separate but equal when they segregated the classes. Here it is separate but almost equal, but separate. Don't come into the institution of marriage. We will see, my lord, the arguments of the state in Plessy very briefly and the holdings in Plessy. And we will also pay a tribute to Justice Harlan, who dissented in 1895. which got, my lord, reinforced in Brown,
Brown ultimately.
Board of Education, and also, my lord, in Loving versus Virginia on the miscegenation aspect, my lord, as to how these very arguments advance with great fervor. That look, this doesn't accord with my belief that it has to be a certain order because it has gone on for centuries. So in that sense, my lord, this is a moment of history which your lordships, my lord, are passing through, which we are passing through, my lord. And my lord, what your lordships are going to lay down is going to have, my lord, an important repercussions for the future. Then the further question, my lord, which has been considerably debated, which has been addressed is, do we look at it from the prism of the statute, or do we start with the prism of fundamental rights, my lord? Because if your lordships found that our claim for the union of marriage, which is the ultimate union in any, my lord, partnership, procreation and mating, my lord, are incidental consequences. If any of us here, my lord, most of us heterosexuals were to be told that what is marriage after all, it is meeting and mating of a youth and a damsel, my lord, we will laugh at the gentleman. It is certainly not that. It may be an incidental part of it. But there are much greater things in a marriage. There is, my lord, coming together of two souls. It is even addressed as, my lord, my lord, an institution which addresses the ego of the individual, where there is understanding. It helps in developing the human personality, a happy marriage. So, my lord, to be told that, my lord, it has to be looked at from the procreation perspective is completely fallacious. Special Marriage Act, my lord, is a secular law. Bommai has reiterated that before the 42nd Amendment, secularism was implicit in the Constitution. If a law like the Special Marriage Act were not to be enacted, my lord, imagine a scenario. Your lordship would have found it a positive obligation in commanding the state to enact it, just as they would not be able to repeal it today, my lord. Assume a state, my lord, to cut the notes wants to spite the face. So, my lord, we need to look at it from the constitutional perspective. The acts will have to be tailored. If there is a right, my lord, which is a fundamental right, it may fit into the statute as it now stands. It may have to be, as Fowry said, to be tailored, to be brought in line. Your lordship may give directives. Let us not forget, my lord, we have challenged the validity of the act. It is in the process of saving the act that your lordship are resorting to these devices. The consequence would be that the act would be struck down and they would be asked to legislate, because it will be a positive obligation in a secular country like ours that you can't leave marriage between people who don't want to go the religious route to be unregulated. There is to be streamlined.
You actually sought for that as the first relief.
We have, my lord, in 3 petitions, direct declarations that the statute, which only recognizes heterosexuals union, if it is to be so construed, is invalid. My petition seeks a declaration. Honestly, an amendment was drafted, but Zainab is not well to execute that affidavit. But, my lord, that is taken care of in Ms. Grover's petition and 2 other petitions. So, in the exercise of trying to save the statute, any guideline your lordship gives, it's far different, my lord, from saying that court is being asked to legislate. Court is making an effort to save the statute in this process, my lord. So, it will not be a legislative exercise, nor can we be told that these are measures which you have to await for Parliament to enact. The century has told us, my lord, that we have no admission to the institution of marriage. We have now come to the sentinel on the Kavi for the same relief. And we are founding it on constitutional grounds. My lord, then the aspect of transgender, because even, my lord, in transgender persons, the 3 categories, the male manifested gender, the female manifested gender, they are entitled to maintain that manifestation. And, my lord, the trans person who doesn't manifest any gender, third gender, are inter se, my lord. Between them, a male to a male is entitled to marry, a female to a female is entitled to marry, a trans person and a trans person is entitled to marry. NALSA, my lord, expressly guarantees a right to marry The union may say it was in 2014 before the act and in the sense of a heterosexual marriage between a trans man and a trans woman. But today, my lord, this issue and the transgender case also, my lord, involves when you say that you are as good as any other citizen and we don't discriminate, this aspect can't be held back only because of an aspect which is nothing attributable to my fault. It is an aspect of nature. Just as you have right-handers, you have left-handers too. Just as, my lord, you have heterosexual people, there are homosexual people who have come out. It is widely, my lord, an accepted nature all over the country. It is not confined to urban, my lord, situation. As your lordship, my lord, the Chief Justice said, maybe in urban areas, my lord, they have been more emboldened to come out and, my lord, seek their reliefs. Lastly, my lord, the note addresses the molding of relief. And, my lord, I have respectfully placed two scenarios, the Fowry scenario, where to save my lord, the statute, they gave an option to amend, which they may resort to, my lord, and streamline the statute. There is another scenario, my lord, where all that is required is to read the word spouse by equalizing it, my lord, and I have placed case law for that, where you equalize them, give them that status, so that, my lord, they are on par. They proceed with their own way. My lord, it infringes nobody else's right if two people get married of the same sex.
So, Mr.
you-
Mr. Vishwanathan,
Yes.
sorry to interrupt you, but just a clarification. Since you mentioned that though there is a relief by virtue of a declaration sought by you and in Vrinda's case, you're willing to go the point of a guideline being laid by court as was being argued by your predecessor.
To save the statute, my lord. Nobody wants a scenario where the act is stuck down lock, stock and barrel, because that is the other consequence of it. So the inquiry is not that, can we do all this, can we read it? The lordship are reading it in to save the statute, not, my lord, so that it is not struck down. I go a step further. Today, it cannot be a scenario where the Special Marriage Act is not even enacted. Assume, my lord, today there is no act.
Point is, non-recognition would itself be an act of constitutionality.
Constitutionality.
And therefore, to save it, you read the statute so as to bring recognition
That is
both to
that.
heterosexual and
My lord, this is, my lord, this will, my lord, give us dignity, give us equality, ensure that message goes from your lordship that we are not looked upon as Justice Albi Sachs said, as an oddity, as an outsider, as some anathema, my lord, to society, some alien, so that, my lord, we get our respect. And once your lordship pronounced, like in Johar, and my lord made that point on the first day, it percolates down to the society, my lord. There is acceptability. Court has said so. My lord, our society is a law-abiding society, my lord. They'll know, oh, this is a point of view, and your lordship reason it out, and that reason percolates. That's how it is accepted, my lord. Today, why is basic structure, my lord, accepted? It is founded on a sound reasoning, my lord. It's 50, 60 years now. Nobody has been able to dislodge it because your lordship's institution gave sound reasoning to it. So all that is required is a message from your lordship, assuming your lordship accept it. In this, my lord, background, just see, my lord, my note. My lord. I will now, my lord, I have extracted most of the paragraphs so that reference to the volumes, my lord. I just want to, my lord.
Then I think you've covered it very comprehensively in what you said. You were
I just
curiously typing away when you were arguing. So I think
I just want to, my lord, since something has been put down, use the time that your lordship gave. My lord, when there was a grim scenario when your lordship debated the time, I wanted to mention, your lordship recollects the 4th book of David Panic.
Yes.
I have to move my car. It came this way. The US judge asked the lawyer, how long are you going to take? Said, don't worry, you are not. I have to move my car because in US after 20 minutes he'll be charged for parking. Now, the only reason I didn't say that was your lordship should not now charge us for parking. That will be a way, my lord, where we cut down our time.
Thanks for the idea.
Someone else pays. Someone else pays for it.
But my lord, the book is titled A Collection of Articles published by Dr. David Panic in The Guardian. Is collected and beautifully written short pieces. I had to move my car.
Who moved my car?
The judges. The earlier one was judges.
Judges and advocates.
My car is a beautiful.
Very, very, my lord, a delightful read.
I haven't.
Speaks about a tourist guide.
By 10th and to me, you know. Beautiful.
Speaks about a tourist guy walking past his office. Make the best use of my time. My lord has the note called, my lord, loaded today. My lord, we are not sure whether it will be loaded.
Marriage and choice
Yes.
begins with that.
My lord, that, only one line from that,
No, which note are we looking at?
that kindly come to my lord Carlos Ball. Sorry, my lord. My lord, we have, my lord, I know your lordship detests hard copies. I have a soft copy, but I also, my lord.
I have a soft copy.
Very
Just one, Carlos.
Just see page 4, my lord,
Page
Carlos
one.
Ball.
Carlos Ball. Right, got it.
Yeah.
Not this one. Not
My lord, may I give a hard copy today?
Something from what was earlier.
Yes, my lord. My lord, after your lordship's queries,
One Goodrich versus
a
department.
Goodrich versus department. My lord, some of them are culled out from cases cited in Fowry. Some independently, my lord, my team has, my lord, been able to collect.
First 10 to 12 pages you have covered as to the meaning of marriage.
Yes, my lord. On marriage and how, my lord, it is.
Quoted Martha Nussbaum also.
Martha Nussbaum is quoted, my lord. A learned friend, one of them was very exercised, my lord, leading and a treatise already quoted by your lordships in Navtej. Yes. I will, my lord, very selectively read so that my learned friends are not hard pressed for their time. But I'll make the use of my time. Yes, my lord.
This is after volume 4.
This is compiled.
Yeah. One second. Mark it. I'm not going to read it. Page 4. Carlos, Morality of Gay Rights, Carlos Ball on how, my lord, constitutive elements of personhood get its full blossoming when the marital union, my lord. As your lordship come down the italicized portion, page 4, my lord. The public recognition, when it is accompanied by social support and encouragement, makes it more likely that the relevant responsibilities will be met. The structure that marriage provides, the obligation that it requires, then can strengthen and make more durable the affectional components of sexual intimacy that are characterized by ongoing commitment and mutuality. The socially recognized marital relationship can provide the structure through which the well-being of the partner becomes inextricably linked to the well-being of the self. Fundamental to it, my lord, is the choice, as my lord, my learned friend Ms. Tara, my lord, wants me to emphasize. The aspect of choice put in bold letters, my lord, through the first 4 paragraphs.
Yes.
My lord, Goodrich said, yearning for security, safe haven, and connection has expressed that express our common humanity. My lord, this is to remove it far away from, my lord, the procreation part which was highlighted. My lord, kindly come over the page on the aspect of, my lord, the equality code, how only one form cannot be determinative. My lord, Fowry, one important passage Dr. Singhvi placed in his note, my lord, but just see the para 13 before the extract, my lord. The South African Constitutional Code felicitously explained that equality does not imply the leveling or homogenization of behavior, but rather it lies at its core in the acknowledgement and acceptance of difference. The court further explained that equality requires persons to be able to accommodate the expression of what is discomfiting.
What like free speech?
Yeah.
Yes, my lord. My lord, kindly mark PDF 2044, my lord, there. In case I have just marked it, but I am not, my lord, going there to read it because these are words from the judgment. PDF 2044, volume 4 of the case law compilation. It is humbly submitted that the petitioner's case before the Honorable Court requires a similar conception of equality. The efforts made herein are for social acceptance and for the citizenry to ultimately acknowledge and accept the difference and to accommodate for the existence of the LGBTQIA plus persons in the same way in which heterosexuals lead their lives. The interests of the heterosexual persons and the LGBT persons do not collide. They coexist in a constitutional realm based on the accommodation of diversity. My lord, that is PDF 2068. My lord, over the page 8, para 16, only because the union says we have prescribed age restrictions, we have prescribed prohibited degree. But they are founded, my lord, on solid, my lord, grounds of health. Kindly see, my lord, how we have addressed it from line about 4 in para 16. In this regard, it is submitted the same is a defense which is the nature of purported facial equality and ought not to be accepted by this court, whereas the restriction of certain class of heterosexual persons from being married, such as minors or other forms of prohibited relationship, directly relate to the state's power to restrict the said marriage on the grounds of either health or such other acceptable grounds. My lord, much was debated on how to apply part 1, part 2, will it be reading in, etc. My lord, till the legislations are streamlined, there is a principle of rule of interpretation. Principles analogous thereto will apply, my lord. Your lordships have extended it in the Limitation Act for courts and tribunals. So apply principles analogous thereto till such time the legislature is streamlined. Your lordship may not want to say both will apply. That is a good suggestion. It has to be accepted as a guideline, as the Honorable Justice Kohli said. Otherwise, principles analogous thereto will apply, my lord. Prohibited degree is, my lord, a established way. It is a health ground. It is scientifically believed that, my lord, the progeny will be
health, not only biological.
Not only biological.
Prohibited degrees goes beyond biological.
Yes, yes, my lord.
There is an element of social and state prohibition.
But they are justifiable, may not apply across the board. I am only saying how to apply it to this spouse category, which your lordship will now add in. Principles analogous thereto, my lord. Nobody can say that that can't be extended. My lord, I have dealt with procreation and childbearing, but I have explained it to my lord. Till today, no upper age limit on marriage. Kindly see, my lord, how the first of the judgments in South Africa, the National Coalition for Gay and Lesbian Equality, my lord, put it. Immigration was denied to, my lord, same-sex partners. Fowry came in 2005. Just I'll read page 11. One second, Anuj. From a legal and constitutional point of view, procreative potential is not a defining character.
Adoption denied to same-sex couples who were recognized by law.
Yes.
Fowry was.
Fowry, my lord, was a same-sex marriage.
Same-sex marriage was recognized by law. And yet what was denied was adoption rights.
Very good. Well, correct it. My understanding was marriage was confined to the common law definition. The lower court had pronounced.
Same-sex.
Yes. Here, my lord, the case in 99 was under the Aliens Act, immigration was confined to married couples in the heterosexual sense. And the defense was of, my lord, inability to procreate. From a legal and constitutional point of view, procreative potential is not a defining characteristic of conjugal relationship. Such a view would be deeply demeaning to couple, whether married or not, who for whatever reasons are incapable of procreating when they commence such relationship or become so at any time thereafter. Likewise, demeaning to couple who commence such a relationship at an age when they no longer have the desire for sexual relations. It is demeaning to adoptive parents to suggest that their family is any less a family, any less entitled to respect and concern than a family with procreated children. I would even hold it to be demeaning of a couple who voluntarily decide not to have children or sexual relation with one another. Lord, constitutional law is tested on the anvil of a common parlance test, my lord. Our own society, there were times, my lord, when people would repeatedly ask, is there any development on the marital front? Today, my lord, it is considered bad etiquette. And our memory is short. There was a UK prime ministerial candidate, I got the news item, who opposed Theresa May and made a deadly statement that she is no mother. What does she know of administration? She had to withdraw her candidature, my lord. Andrea Leadsom. That is the, my lord, sensitivity with which people have arrived. So this is no issue at all. Surprising that, my lord, it was argued with such vehemence. The candidate withdrew from the party contest before May was elected on this ground, my lord. Andrea Leadsom. It's only illustrative, my lord, as to how society all over has changed. Our society has changed, my lord. My lord, Obergefell on the point that, my lord, you can't see marriage through the narrow lens of procreation.
Asexual.
Yes. My lord, there is one important aspect which My lord, page 12, para 26, my lord, is a very important notification of the Central Adoption Resource Authority, which bars single applicant in a live-in relationship from adoption because they are not considered a stable family. So, my lord, it is all the more why, my lord, marriage ought to be permitted. Now, we will proceed on the basis that this is valid because at the moment we are not engaged with the constitutional validity of this. But if this is the view of the union, my lord, it only, my lord, comports with our theory that permit us to marry because then marriage will lend that stability for children to be, my lord, brought up. My lord, Indian Psychiatry Association, similar directions in Navtej was there. We are relying on similar directions, my lord. But what is of great interest is a law in the anvil by the 118th report of, my lord, the Parliamentary Standing Committee, wanting a comprehensive law for everybody, harmonizing Hindu adoption maintenance, juvenile justice, which would cover also the LGBTQ community, my lord. This is a very salutary development by our parliamentary committee. And, my lord, this itself shows that, my lord, adoption is a means of rearing children, even in our country. And the only country, my lord, which collected an empirical data in a court case, which we could locate, was a Hawaiian case, my lord, where on remand from the Supreme Court of Hawaii, they took empirical data and evidence to show and concluded that there is no evidence to show that gay, lesbian, and same-sex couple do not provide children, my lord, the safety, security, and the upbringing they require. My lord, long back in our country, the law was all that is required is the welfare of the child. My lord. If I recollect, it was Annie Besant versus Krishnamurti. If that is applied, my lord, it doesn't matter whether it's a heterosexual couple or a homosexual couple, and all these findings, my lord, based on evidence that they are as well suited as heterosexual couple to bring up children, my lord. So to say, my lord,
and Mr. Vishwanathan, what happens when there is a heterosexual couple and when the child sees domestic violence? Will that child grow up in a normal atmosphere?
Yes.
Of a father becoming an alcoholic, coming home and thrashing the mother every night
Precisely, my lord.
and asking for money for alcohol. I mean, this is so much for heterosexual. There are no absolutes, as I said, even at the risk of getting trolled. But
Lord,
but now this has become the name of the game for judges to confront. Answers to what we say in the court are in the trolls, not in the court, you know.
my lord, think of one more step, my lord. If this is accepted procreation, what if Parliament says that I give only life interest to, my lord, LGBTQ and let it revert to the others because anyway you are not going to have children. We will now revert it will escheat to government. So we'll keep it in the family by giving you life interest and revert it because you can't procreate.
Give ideas.
No, my lord, I'm saying the consequence, disastrous consequence of this argument. They are entitled to their security, their living, they can pass it on to their children, they can will it away. My lord, if this argument is taken to its logical end, you don't procreate, you don't vote, because you're saying for the future generation, because you can't procreate.
And by that token, a law can be made to say that if there is a couple who are 50 years old, they don't have children, they won't have a right to vote. I mean, see, these kind of possibilities are extremes. I mean, we have to keep it within the realms of probability. Let us not, as rhetoric flourish, maybe you can.
But my lord, it will lead to that. Tomorrow, if your lordship's imprimatur is obtained, my lord, I'm only saying in the hypothetical scenario, how do we stop this, my lord? Same judgments will be cited. So, and my lord, this couple who are beyond the age, my lord, of producing children, that there is no embargo on marriage has been used as an illustration. And your lordship notice, my lord, I repeat the point, no upper age limit. 18 and 21 are the minimum age limits. Sorry.
Will happen. Law which prohibits, like it had happened in other country, if it prohibits position will be before the court to be struck.
So
down.
eugenics.
Therefore, it is not the other way.
You see, Mr. Vishwanathan, we have looked at societies, we have seen history. Eugenics has been practiced in Germany, in
US, my lord.
The US as well.
That Buck versus Bell.
So
my lord,
therefore, see, we have to see within the fabric of our democratic setup and our plural society whether these are within the realms of possibility. When you make this argument,
my lord, I have, if Chief Justice Holmes
Could say one
could say
generation of
three
imbeciles is
generations of
enough.
imbeciles are enough and uphold sterilization, my lord, Holmes. And
looking at a different age.
my lord, and the reality,
That age after Plessy.
my lord,
That
and
was an age which lived with Plessy. So we can't just, star everyone in one this
my lord,
black or white.
and the
You had Dred Scott because it was
my lord, and there is a, sorry, my lord was.
No, I'm not saying that.
My lord, is,
Fruit is not necessary.
it is only an illustrative to show this procreation is presented, my lord, across the world spectrum.
The point is
My lord, just coming back to that, my lord, there is a study by Adam Cohen in his book Buck versus Bell that it appears the report of that Bell that these are, my lord, Down syndrome people, it was also false. The children have topped the, my lord, the school. The mother, my lord, had done well, but they were all, my lord, sterilized, saying 3 generations of eugenics of imbeciles are enough. My lord rightly mentioned, my lord. So this is actually the eugenic scenario, but I understand. But I'm saying, my lord, procreation cannot be placed at that pedestal, my lord, that as if the entire institution is for, my lord, procreation. It is in that context, my lord. Yes.
You can't say it can't be. You can say certainly it cannot be
My lord,
placed at that pedestal.
my lord, I'll take it. I'll only put it this much that gay, lesbian, LGBTQ parents are as much qualified to, my lord, rear children, adopt and rear children, my lord, as bring up children, as much as, my lord, the heterosexual parents are. The next point has already
really put it in this way that, same-sex couples seek the same benefits of marriage, save and except for procreation.
Yes.
And there are a whole range of benefits which cohabitation and marriage provides, which same-sex couples assert for themselves.
Denied. Family pension, my lord, is an important aspect.
I think the word Mr. Ramachandran put it, it's a gateway.
Gateway.
It's a gateway. It opens up so many possibilities.
Very great.
So many
That's the
rights,
correct
so
way to
many
look at it.
entitlements, those which you can enjoy. And those which, of course, you cannot be part of, you don't.
That's correct.
You take it as it is.
But the choice, my lord, should be given. That's what my lord is. The choice should be available. It's up to me to enter, not enter, exit.
Just as in the case of heterosexual couples now, with the spread of education, the pressures of, of the modern age, increasingly couples are either childless or single-child couples. And therefore, you see even populous countries like China now really losing out on the demographic dividend as populations are increasingly becoming elderly. Why? Because the young who are highly educated do not want to have more children. But that's a matter of choice. That's a matter of choice.
Heterosexual marriages doesn't depend upon children.
Correct, my lord. Correct. That's as simple as that.
Vishwanathan, this notion, that it's only, the very highly educated or the elitist who want a reduced number of children. You have to only talk to people who work for you in cities like in our city. You talk to people who are close to you and find that, most of them say that we want to have one child. My chauffeur has a daughter.
You know, a prominent constitutional lawyer.
A daughter. So this is now becoming there is
It is on
there's a
record.
degree of awareness, also a feeling that, well, people are moving away from this notion that, well, you must have a boy. That's the spread of education, the impact of education, that you may have just a single child, that you may have a...
It's on record that a prominent constitutional lawyer, my lord, and his wife decided not to have children so that they could dedicate themselves to their, my lord, activities and practice society. My lord, sir. I'm just coming to that.
My driver
Only one headline in 15, my lord, the subheading from Barnett, my lord, that memorable line, fundamental rights may not be submitted to vote, they depend on the outcome of no elections. And more felicitously put by my lord Baba Sahib at page 16 bottom, in the context of the Hindu law code, my lord, that I am not, kindly see the last 4 lines of the quotation. I have not the slightest doubt in my mind that the provisions of this bill are in perfect consonance with the conscience of the community. And I therefore no hesitation in putting forth this measure, although it may be a matter of fact that a large majority of our countrymen do not accept it. And my lord, history is recorded that there were several dignitaries who had objection to it. Legal opinions had to be taken. Mr. Satilwat gave an opinion, Lady Krishnamayar gave an opinion about, my lord, signing the bill. I have read somewhere that Babu Rajendra Prasad had reservations on some parts of the bill.
Some part.
And opinions were taken, my lord. Written opinions were taken. There's an opinion published in Statesman Among Jurists of Lady Krishnamayar. And I think Mr. Satilwat also, my lord, gave an opinion about the binding nature of the aid and advice. So, my lord, views will be there as we transition in society, as we evolve in society, my lord. There will be a large body of status quos. But, my lord, one will only reason it out, my lord, with them. And, my lord, no better way than, my lord, a recent, my lord, verdict which your lordship will ultimately consider and pronounce one way or the other. My lord, rest your
The first bill. It's the Hindu code.
Yeah. 54 was the first one, my lord. There is a subsequent one also.
Look at it. It was the first attempt to break down barriers.
Right.
The endogamous society, even among
Hindus.
Apart from that, it gave, of course, a long title says enabling a platform for interfaith marriage.
Absolutely. My lord, women got property rights in the sense of self-acquired. First tripital in section 6 on the death of my lord, the Kopparsonary. Kopparsonary came 2005 all over India. Tamil Nadu introduced it, my lord, in 89. But Karnataka, Maharashtra. But, my lord, kindly see, my lord, given property rights, except that there has to be a death and then notional partition and a first tripital at that stage. Now they are parts of the Kopparsonary. And when 23 was deleted in the 2005 Act, of course, we argue, my lord, under the cab rank rule. I argued saying it can't apply to pending suits. Your lordship rejected it in Gokul versus, my lord, Geeta versus Shekhar.
These are statutory interventions.
Interventions. Your lordship said no. 23, which said for a dwelling house partition, a female must tag along a male relative, is per se, my lord, discriminatory. Merely because it was deleted in 2005, I will not say it has no application to pending suits. You may argue that suits crystallized, law crystallized on the date of the suit. My lord, your lordship could skip this portion, my lord, and quickly go over to, my lord, the 18. I am not going to read the 3 pages, my lord, it's carrying coal to Newcastle. My lord, 18 Roman 5, my lord. And I, my lord, find a lot of reverberations in the ratio in the miscegenation, my lord, law. To say that heterosexual marriages are the norm and are foundational to existence of the state rings a similarity to the theoretical underpinnings of the miscegenation statutes, my lord. Just see, my lord, Gibson, which preceded Loving, my lord. Gibson followed Philadelphia, Westchester. Just permit me to read 5 lines, the underlined ones, my lord, to see the similarity, my lord, because these are moments in history which have already passed through, my lord. The question is one of difference, not of superiority or inferiority. Why the Creator made one black and the other white, we do not know. But the fact is apparent, and the races are distinct, each producing its own kind and following the peculiar law of its constitution. Conceding equality with natures as perfect and rights as sacred, yet God has made them dissimilar, with those natural instincts and feelings which He always imparts to His creatures, which He intends that they will not overstep the natural boundaries He has assigned to them. The natural which forbids their intermarriage and that social law amalgamation which leads to a corruption of races is as clearly divine as that which imparted to them different natures. The tendency of intimate social intermixture is to amalgamation contrary to the law of races. The separation of the white and black races upon the surface of the globe is a fact equally apparent. Why this is so, it is not necessary to speculate, but the fact of a distribution of men by race and color is as visible in the providential arrangement of the earth as that of heat and cold. The natural separation of the races is therefore an undeniable fact, and all social organizations which lead to their amalgamation are repugnant to the law of nature. Further down in the underlined portion, it is simply to say that following the order of divine providence, human authority ought not to compel this widely separated race to intermix. Naim followed it. Then came, my lord, loving. But see, my lord, even in loving, what the holding of the code below was para 42. My lord, Lordship may mark PDF in loving, my lord, 1770 in para 42, where it says 1762 volume 4.
1770.
1770. 8 pages, my lord, in this volume is the difference. Almighty God created the races white, black, yellow, Malay, and red, and he placed them on separate continents. And but for the interference with this arrangement, there would be no cause for such marriages. The fact that he separated the races shows that he did not intend for the races to mix. But how it was overturned. However, the court emphatically rejected this reasoning, and the defenses taken by holding the miscegenation statute rests solely on the distinction based on race, and that such classification did not amount to accomplishment of a permissible state objective. It further concluded that the denial of freedom of marriage, which is fundamental to a person's existence, would amount to violation of the equality principle. My lord, 1778 and 1779 PDF. My lord, I'll leave it for your lordships to read at leisure. My lord.
See, in the US Supreme Court in 1923, as recent as, of course, this was a few years before Brown, they denied citizenship to Bhagat Singh Thind. Now he claimed, I'm a white. They said, no, you have to be a Caucasian.
Caucasian. Yes. Now, my lord, we are, my lord, more emphatic, both in Lata Singh, my lord, Shafin Jan, where, my lord, the Honorable Chief Justice, as your lordship then spoke, and, my lord, Lakshmi Bai, my lord, the Honorable Justice called, emphatic that, my lord, these are now things of the past. And your lordship, my lord, gave a powerful, my lord, opinion. My lord, the Shafin Jan is PDF 1162, that has been read, I think. And Lakshmi Bai, my lord, Chandrachud is PDF 740, my lord. I am not, my lord, reading it. My lord, according to me, this is the equivalent of saying separate, almost equal but separate. I can't say equal as they said, but they were just segregating. Here, my lord, almost equal but separate, my lord, completely unacceptable under our, my lord, constitutional scheme. And in that context, my lord, if your lordship over the page sees Plessy, my lord. I've always been curious to read, my lord, Plessy, because Brown, my lord, gets all the attention. Actually, it appears Brown was not the first case. Lord, just see, my lord, page 23 bottom, para 40.
End of the day, we'll ask him to wrap up.
8. The Union of India in its counter affidavit for this honorable court has referred to the decision of Navtej Singh Johar as merely decriminalizing consensual sexual intercourse between persons of the same sex and nothing more. Note para 48, minute, page 2.
Yes.
Further, the union has referred, fourth line, we refer to the same-sex relationship as unions, which may not be unlawful, but not all these unions can be given the recognition under the institution of marriage. This apart is also stated that the law is neutral and in line with the principle of equality in as much as it equally prevents other heterosexual unions, such as live-in relationship, from being brought into the fold of marriage. Now, my lord, kindly see, my lord, 3 paragraphs in Plessy 24. My lord, this Plessy will be in an additional compilation filed last night, my lord, because in terms of
we look at Plessy, Mr.
Lordship will look at it. Just mark, my lord, page para 51, Roman 123, a statute which founds itself on the distinction of humans based on the color of 2 races has no tendency to destroy the legal equality of the 2 races. Laws permitting and even requiring separation of 2 races where they are liable to be brought into contact do not necessarily imply inferiority of either race. Very similar argument which we are advancing. If the civil and political rights of both races are equal, one cannot be inferior to the other civilly or politically. If one race is inferior to the other socially, the constitution cannot put them on the same plane. My lord, but my lord, hats off to Justice Harlan, 1895, at page 297 of the reports, my lord, in the additional compilation, who was dissenting in Plessy. Harlan held that the spatial neutrality would not save such practice from the full force of the equality jurisprudence.
Tale about Plessy is there also this man had bought a railroad ticket.
Yes,
and he was thrown out. This was in 1893.
Like Gandhi.
Same 1893, Gandhiji was thrown out from the tree.
Port Chef's tea room.
Peter Maritzburg.
Port Chef's tea room. That was, my lord, a graphic visual which stuck me.
Don't Peter Maritzburg.
It is Justice Harlan held that facial 25 top neutrality would not save such practice from full force of the equality jurisprudence. It was opinion that under the guise of equal accommodation, people of color were compelled to travel separately. Further noted that destinies of races were indissolubly linked together, and the state's endorsement of this segregation would be to permit the seeds of race hate to be planted under the sanction of law. Your Lordship, equalizing it, my Lord, will adjust the affairs for future, and everybody, my Lord, would live happily ever after. My Lord, Brown versus Board of Education came down on the separate but equal doctrine, only limited to a situation of public education. But my Lord, there are other situations where separate but equal for health needs and privacy may be acceptable, but not, my Lord, in where the state has no compelling interest. My Lord, I have already, my Lord, my predecessors have already dealt with the over the page, because I want to go to the TG Act part, my Lord. discrimination, education, removal of discrimination, government to formulate welfare measures, non-discrimination, right?
Let's go now to the Transgender Act. I think
Yes,
let's go
transgender, my lord, page 29, my lord.
Yeah.
I am leaving the portion on from disgust to humanity, my lord.
No, that's very beautifully put actually in
Yeah,
Matha.
you'll have to read it later.
We'll read it. I already scanned it.
Lordship,
when you were up.
my lord, page 29, my lord, as far as the transgenders are concerned, I want to make it very clear, my lord, all three categories there, my lord, the male manifested, the my lord, female, and my lord, the undefined, my lord, the third gender, would seek your lordship's indulgence in permitting them to have marriage between, my lord, the categories. That is, male for male, female for female, and trans for trans, my lord, because that part is similar here also. Nalsa judgment, my lord, passages of which I have given at page 33 bottom, my lord, because a large number of relevant passages, because it's a long judgment. Just go to 33, my lord, and mark this footnote so that your lordship may not have to go to any other paragraph.
Para 33 or page?
33 footnote 8, my lord. Yeah, is it, my lord?
Yes, yes, Nalsa.
Nalsa, just mark these paragraphs. Recognizes right to marry. That is, my lord, we have quoted that. In between, my lord, a trans man and a trans woman, that can't be denied. But this is one step more, because kindly come back to my lord.
Right.
I know. That is between irrespective. No, but Nalsa. Nalsa.
Yes.
I just want to read para 81 so that my proposition is clear. What Nalsa said was, in quotation, which is also para 81, Article 14, 15, 16, 19, and 21 above discussed would indicate do not exclude hijras, transgenders from their ambit. For the Indian law on the whole recognize the paradigm of binary genders of male and female based on one's biological sex. As already indicated, we cannot accept the Corbett principle of biological tests. Rather, we prefer to follow the psyche of the person determining sex and gender and prefer the psychological test instead of the biological test. Binary notion of gender reflects in the Penal Code 1860, for example, 8, 10, etc., and also in the laws related to marriage, adoption, divorce, inheritance, succession, and other welfare legislation like NREGA 2005, etc. Non-recognition of the identity of hijras, transgenders in the various legislation denies them equal protection of the law, and they face widespread discrimination. Then, my lord, 119 is Honorable Justice Sikri. Therefore, gender identification becomes very essential component which is required for enjoying civil rights by this community. It is only with this recognition that many rights attached to sexual recognition as third gender would be available to this community more meaningfully. Right to vote, right to own property, right to marry, right to claim a formal identity through a passport and a ration card, driver's license, right to education, employment, health, and so on. The 2019 Act, my lord, recognizes right not to be discriminated, recognizes, my lord, in section 4, the right to manifest any gender. In, my lord, section 5 and 6, to be recognized as, my lord, a third gender person. So, my lord, this right to marry is, my lord, inter se the Milord transgenders, correct? All the, no, what, how is your understanding?
Sir, it can be any
You are, you explain. Well, Ms. Tara wants to explain something on 1 minute on this, Milord.
My lord, simply that a trans person has the right to marry a person of choice, irrespective of sexual orientation and gender identity. Simply.
Yeah. And that reiteration, my lord, is sought in the present proceeding. But your lordship may also make a note, my lord. Kindly come back to 64 onwards, my lord. Yeah, para 64. Thank you, thank you. My lord, yes, 63 is the definition. Transgender person means a person whose gender does not match with the gender assigned to that person at birth and include trans man or trans woman, whether or not such person has undergone sex reassignment surgery or hormone therapy. That is optional, that can't be compelled, that can't be determinative, or laser therapy or such other therapy. Person with intersex variations, gender queer, and persons having such socio-cultural identities as Kinir, Hijra, Aravani, and Jokta. My lord, kindly come to 65, my lord, for the proposition. Provisions of the Act are therefore not exhaustive in nature. 20 of the Transgender Act say that the Act is not in derogation, but in addition to any other law in force. There is nothing in the TG Act to suggest that transgender individuals are barred from the institution of marriage. 67, my lord. It cannot be argued by the respondent that is the state that the rights enshrined in the TG Act are the extent of the rights available under Indian law to transgender persons, as this would tantamount to contempt of the expansive formulation of the rights in NALSA. Indeed, the state's argument that TG Act confines and captures the extent of rights available to the transgender community is further challenged by the provisions of other laws which bring intersex variation and other sexual characteristics within its protective ambit. For example, Adoption regulations of 2022, we have annexed that, propounded under the Juvenile Justice Act, variations to genitals are classified under special needs, presumably to prevent such children being rejected by prospective adoptive parents on the basis of prejudice. It will be a logical fallacy to argue that those children with variations of sexual characteristics are entitled to the love and care of the family, the same child as an adult be barred from adopting, fostering, or birthing a child within the framework of a stable marital union and giving it necessary care and protection. 70, my lord, this is how the biological men, biological women came in the pleadings. Respectfully submitted, the institution of marriage cannot be prerogative of biological men and biological women alone. In view of Section 4 of the TG Act, read with Section 7 of the TG Act, further it is now well-established concept that gender is distinguishable from sex and gender can be expressed or performed in myriad of ways. When the legislation itself provides for self-perceived gender identity, the state may be stopped from relying on an outmoded formulation of gender based on the presence of certain secondary sexual characteristics. 2C of the Act defines family as a group of people related by blood or marriage or by adoption made in accordance with law. Traditionally, members of the trans community have found love and acceptance from found families or families of choice.
Now, Mr. Vishwanath, last 2 minutes before you conclude, tell us on reliefs.
Relief,
Just
kindly
formulate
come,
now, that's it.
Kindly come to, my lord. I have written it down, my lord. Kindly come to 39, para 92, my lord.
Just tell us what's your...
my lord, since it is a challenge to the validity, and if your lordships find that exclusion of, my lord, couple other than heterosexual couple from the recognition of the status and
will make it invalid.
Marriage would make the provision invalid. The only way to save it would be, my lord, to equalize it. And that equalizing principle, my lord, is a device your lordships have adopted in our courts. Kindly see, my lord, the two case laws cited, page para 97 and 98. Vishnu Das Hundumal versus State of MP, followed, my lord, in, I will read para 98, with respect to the concept of reading into the statute, respectfully submitted that the same is now well recognized in our Indian jurisprudence, adopted by the sort in various instances. One such recent decision is Association of Old Settlers of Sikkim. My lord, kindly mark, my lord, para 44 at page 335 of Honorable Justice M.R. Shah, and my lord, para 147, 148, 150 of Justice Nagaratna, Honorable Justice Nagaratna at page 378, held that exclusion of old Indian settlers who were permanently settled in Sikkim prior to merger of Sikkim with India on 26/4/75 from the definition of Sikkimis in section 1026 AAA of the Income Tax Act, violative of Article 14. Upon holding the exclusion as unconstitutional, it was ordered that all old Indian settlers were entitled to exemption benefits provided under the said provision in order to sustain the constitutionality of the said provision. So, my lord, Indian settlers who did not give up citizenship were not entered in the Sikkim register. Income Tax Act said all those in the Sikkim register are exempted from income tax. It was argued, my lord, I had the privilege of assisting the court, citing Vishnudas, Handimal and other cases, my lord, including Nakara, that the provision need not be struck down, but the left out categories, my lord, are added to it and equalized. Lordships accepted it. In fact, Honorable Justice Nagaratna laid down and said it is up to Parliament to amend, but all will be entitled to exemption by equalizing it. So if your Lordship apply that, all that is required, my lord, is for the time being to add husband, wife or spouse. Rest will, my lord, follow. They need to tailor it. Or the Fowry model, my lord.
Thank you, Mr.
Very grateful, my lord. My lord, age, on the age issue, there is a request that in case the Special Marriage Act is to be interpreted, my lord, the default age be kept at 18 for, my lord, the third gender. And so, keeping in view the Indian Majority Act, my lord, so that there is no, my lord, disparity there or a doubt or ambiguity there. It may be said that man and female, there is an age, but for the third gender, it may be kept at the least common denominator of 18, my lord, because it is a right which is recognized. But, my lord, the main point is, if fundamental right is recognized, my lord, legislation will have to be suitably tailored to uphold validity. It's a secular law, there's an obligation to enact, and, my lord, they will have to put in place, my lord, all these issues of whether offences, my lord, will disqualify, what will disqualify. Your Lordship need not, as Honorable Justice Cole raised that point. Once the broad parameters are laid down, my lord, and, my lord, that is our respectful submission, my lord. I am very grateful, my lord. I am grateful. Grateful.
Thari, Anita Shenoy, Dr. Menaka Guruswamy, Saurav Kripal, Vindra Gogar, Karuna Nandi, Arundhati Kajju, Raghav Avasti, Shivam Singh, Namit Saxena, and Manu Shivnath. We, in any case, will be completing the hearings on this side on Monday. So please, I would suggest that all of you, learned counsel, have a meeting between yourselves, that you ration time between yourselves. It's very difficult for judges to, you know, to curtail anybody and, you know. So between yourselves, if you do it, it becomes much easier for us. So please.
Which is on a very different footing. There is a trans woman who converted to a woman. She entered into formal marriage under Hindu.
So what we'll tell you, the request is this. Since Ms. Geeta Luthra is next, yes, anybody who wants to, we would request Ms. Geeta Luthra to be the nodal senior counsel. Everybody can just have a word with her. Either you do it on a video chat or whatever on Friday or Saturday. That between you, including the interveners, somebody who wants to say something can, and Ms. Luthra will then give us in the morning the order so that we finish so many by lunch and so many in the afternoon.
Very good.
All right. So even the interveners, please do talk to Ms. Geeta Luthra so that she will then distribute time between all of you so that Monday we have to finish this side.
There are few interventions on this side of it.
Oh, yes, of course. Then that you give to Mr. Solicitor's Junior. All right. Thank you.
Grateful.